I have your lordship sleep late to mention this matter was mentioned on Monday late. Your lordship directed the matter to be listed today at the top late, along with other matters.
Yes.
Along with other matters which involves awarding 10 marks in second SLS late. Unfortunately, this is not in the list today.
Not in the list. দেখুন তো কি ব্যাপার?
Would it be possible to prepare a supplementary list and take it after 2 p.m.?
ফাইল কোথায়?
My lord, may I have your lordship's kind leave to mention one matter? Monday I mentioned the matter that I have filed it, and your lordship directed that you give the date on Friday, it will appear. On Thursday, it will appear. My lord, it's a new motion. Yes, today is the listing date, but the matter has not come up. There is urgency. Why I tell your lordship? My lord, I have specifically pleaded in my writ petition that the 10 marks should be given, should not be, should be given.
Tomorrow. Serve notice.
Identical matter, I want to move it to Malata. Let it appear tomorrow. Malata, I will serve.
It is new.
10 marks matter?
Yes, Malata.
All right.
Tomorrow.
Impleadment? Why impleadment?
Because I am not a party. I am issue is same. Whether traditional traditional minimum should not be considered. We are saying that we are better in the sense that we were in service and the service.
No, if you have an issue, why don't you file a writ petition?
No, there was no requirement for me to file a writ petition unless this challenge was there before the court. So I only say that lordship hears us also by deciding.
I do not know who you are. I do not know who the petitioner is. I know nothing of the matter. Let the matter be placed before the court, then I'll think.
I only raise for this.
File application for addition.
And lordship only tag it.
Your application is not ready. The writ petition is, well, let it be filed, I'll see. Please don't mention today. Come on Monday. Why? Which one? 1353. Released from the list for want of determination. What is your name? Are you the on record?
No, actual doctor is not.
Where is the on record?
Your lordship is the same chamber where your lordship like to make.
And are you sure?
Yes,
1353.
1353.
Released for want of determination. Record his appearance.
Your ladyship, mentioning for, may I be permitted to mention for correction? I'm mentioning for correction of name of the learned advocates who appeared on behalf of Central School Service Commission in the order passed on 3rd November.
Wrongly gone down?
Yes.
What should be the name?
The name should be Mr. Arko Kumar Nang, Mr. Rahul Kumar Singh. It has appeared at Mr. Saurav Mitro.
All right, give.
May I permitted to mention?
Was returnable today. The matters are not there. I have annexed the order. There are 4 matters like which may just end up your lordship to see.
Please come on Monday. I'll include matters, not today.
May I permitted to mention for inclusion, my lord?
This was that those 4 matters the petitioner is not being paid to the silence.
Wait, come next week.
For inclusion, my lord. Transfer matter for inclusion in the list, my lord.
For inclusion, come on Monday. Lot of matters are there.
May I permit to mention for one inclusion of matter?
Monday.
My lord, this matter is fixed on 4th. On earlier bench, but this matter is not appeared. Kindly, there is some urgency. This is a Christian minority school. Then on earlier occasion, petitioner tried to get transfer. Petitioner's son has autism, and due to non-availability of school, the petitioner did not get transfer in earlier location. Though, but this time,
Monday, please mention.
There is some urgency. Otherwise, only one school is vacant, in Malda district,
Yes.
and there is a specific direction to be appear on 4th,
So
of
4th
this
has
month.
gone.
This matter is not come in the list, that
Yes,
is why
yes.
I
Mention on Monday. Yes.
Permitted to mention 5 matters what are relating to award of 10 marks, my lord. It is to be appeared on 12th, my lord, because I have mentioned with the my lord presentation.
12th.
If your lordship.
So 12th it will appear. The other matters will be taken up. Any order passed will cover your matter also. So no.
My lord, one pension matter and one transfer matter from the combined list for segregation.
From the combined list,
My lord.
give the number.
My lord, item number 196, I want to withdraw the application, not press this application because my grievances has been ventilated.
196
196.
of combined
Press list,
please list.
material list. The contempt application,
It's a contempt.
my lord.
196.
Biswajit,
You are for the petitioner?
my lord, I am for the petition.
Shaurodeep Dotto?
My lord, I am so.
Alright, একটা order লিখে নিন তো। Learned advocate for the petitioner submits upon instruction that his grievance. Oh, ঠিক আছে। Grievance already redressed.
Right.
Alright.
My lord, and another matter, my lord, item number 298. That is matter, my lord, I am for the panchayat. My lord, there was a direction from your lordship to the officer in charge Alambagh police station during demolition period, they will give us security. Now, on the date of demolition process, we have been attacked. FIO, Panchayat Pradhan has been attacked. FIO was lost, 2% arrested, 8% are still absconding. So, my lord, I am seeking one direction upon the SP or SDO because order has been passed by the SDO. So that it can be done.
This way it cannot be done. Let it be called on. Yes,
Right.
call the list, please. Record not found. কি হয়ে গেছে? By order dated 18th March 2011, this writ petition has been converted from the original side jurisdiction to the appellate side jurisdiction. Stop. Let the writ petition in the original side accordingly be treated as disposed of. Next one also same.
Number 2. For I appear for the petitioner.
Yes.
The grievance of the petitioner is
Has there been a change in the on record?
no.
No.
Anita Shaw.
This is the original side matter going on.
Yes.
Item 3, Bhagwan Singh.
No, item 4 has been called.
Oh, this is 4. Yes.
Now, my lord, the case of the petitioner is that, my lord, I was appointed in 2010, my lord, in a de-getting school at Borobazar. Now, my lord, my appointment was confirmed from 1st of December 2014. My lord, there were orders of the High Court regarding, my lord, my approval of appointment, and direction was given to the District Inspector of Schools, Kolkata, my lord, to consider the case. Kindly turns to page. But I'm not going into that because this is a different case. But where I have questioned the show cause notice.
I can see from the earlier order recorded that 4th of June, there was a direction for appearance of the petitioner before the inquiry officer.
Yes.
What happened?
My lord, we appeared before the inquiry officer. My lord, the inquiry process has not been proceeded further. But my case is, my lord, whether the charge sheet is maintainable or not. Because it is a de-getting school, and your lordship knows that, my lord, 2018 disciplinary rules does not apply in de-getting schools. My lord, the charge sheet that has been, my lord, annexed to the petition, if your lordship kindly sees the charge sheet at page 50. I
Who is
request,
your other side?
my lord, the school has been put on notice now. Well, the mail has been sent to the school, well, requesting the school to appear today, that the matter will be
4, 5, 6. Respondent numbers 4, 5, and 6.
4, 5, and 6. Yes.
There is a learned counsel representing. Why don't you serve upon the learned
The Learned Council has given no objection.
objection?
Yes. I have inquired. He is my friend. I have inquired from Devapriyo. He has given no objection. So, I have issued a fresh notice to the school. If your lordship so pleases, I will serve the school once again.
Because in their absence, it cannot
Absolutely.
be done.
Absolutely.
And
I don't want.
state is also an important party. Please
Yes.
come.
If your
One
lordship
appears
kindly
on behalf of the
fixes on
respondent.
Monday,
Stop. Let the respondents be notified once again. Stop. Relist on 12th,
well, I have
Wednesday.
4 matters on Monday.
So what?
Acha, theek hai.
You are coming here every day.
Very good. Sure.
Also, kindly come page 53.
My lord, in this matter, Jyoti Banerjee appear on behalf of state, my lord. Kindly short pass out, he engaged another court, my lord.
There is another learned advocate who is assisting him. Where is
Yes,
he?
yes, lord. Sir.
Call him.
First 10 minutes, my lord, kindly.
Also, kindly come page 53. This is for this reason also I mentioned this.
There was a direction upon the DI to file a report in the form of
I have
affidavit.
mentioned this matter for the reason. Kindly come page 53.
Yeah,
53.
Page 53, P3, page 53.
Yes.
No, so lots of the
Oh, I appeared in this matter.
that's
Acha,
why-
thik hai, please come. From the documents annexed to the writ petition, it appears that I appeared for the petitioner in the matter at one point of time. Stop. Accordingly, the matter stands released from the list of this bench. On personal ground, stop. Let the same be placed before the Honorable Chief Justice, within bracket acting, acting Chief Justice for necessary assignment.
Yes. Okay, my lord.
Lord, item number 2, my lord, I am for the petitioner.
আপনি
Right,
require
your lordship, what are
permission,
the
my lord.
facts, my lord? My lord, this is my supplementary affidavit. I have served also. My lord, the facts is, my lord, the petitioner is a fresh candidate who participated in the second SLST 2025 for pursuant to the Supreme Court order in the new recruitment. My lord, in the recruitment rules, if your lordship straightway come to page 140.
Yes.
My lord, 140, my lord, I am reading, my lord, way of evaluation. My lord, your lordship has got that selection for the post of assistant teacher for classes 9 and 10.
Yes.
Thereafter, my lord, 1 is written examination, 60 marks, 2 is academics. My lord, thereafter 2B, your lordship has seen 2B prior teaching experience. My lord, I am reading at secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for each year. So, my lord, any teacher who is working in a government or a government sponsored school in a substantive post is entitled to this teaching experience marks, my lord. My lord, we are part-time teachers working in a government sponsored school in West Bengal. My lord, we, at the time of filling up the online application form, my lord, I have also annexed that it was so designed that I could not fill up the application form, my lord. Kindly come to page 144. This is a screenshot I have given. Why I have come up before your lordship. My lord, kindly see. Are you working as an assistant teacher in any aided school? Yes. Thereafter, existing roll number. I do not have any roll number because roll number can only be possessed by the candidate of 2016 selection process who were permanently appointed. So, my lord, I could not fill up this application form, all being mandatory field. So, my lord, I came up before this honorable court. Before that, my lord, a coordinate bench in case of a central school, contractual teacher, central school, passed an order, my lord, that she has to be given the opportunity to fill up this application form. Thereafter, my lord, in similar orders, a division bench of this honorable court had the occasion to consider. The division bench, my lord, I have the order on last day, passed an order directing the commission, you considered their application and if it is a substantive post, you award marks. Now, my lord, whether my post is substantive, my lord, kindly see the supplementary affidavit. I have also served supplementary. No. Supplementary.
Yes.
My lord, your lordship sees the first page of the supplementary affidavit. The school has issued, my lord, the certificate. Amar copy check. My lord, I have this is the certificate of every teachers, my lord, I have appointed. All are substantive. What, my lord, I am only what I have
No,
only
just tell me these certificates issued by this school. Were you not appointed in the regular manner?
My lord, I was not appointed in I have been appointed as a part-time teacher in classes 11, 12
Yes.
in the school. And my experience certificate is also annexed in the writ petition.
Where is the appointment letter?
My lord, page 25, my lord, at that point, since my appointment is by a managing committee, my lord,
Yes.
there was, for all, there is no appointment letter, but page 25, if your lordship kindly comes, page 25.
Of the writ
Writ
petition. Who paid your salary?
My lord, the school.
Look.
School.
School paid my salary. But
How? Online mode?
no,
Cash?
it's online mode.
Online mode?
Online mode. My lord, the question is, the rule says any teacher of a government sponsored school. And my lord, in case the
And the posts in which y'all were engaged, were those posts sanctioned posts?
Yes, my lord, that is, my lord, at page 3 of my supplementary affidavit. My lord, we are if your lordship calls for a report, your lordship will find that in classes 11, 12, we are the only teacher teaching the subject. Everywhere. My lord, may I read one experience. This is to certify that so-and-so residing at village so-and-so is high school. He teaches the subject of education in the students of classes 11, 12 in the higher
minute.
secondary school.
Last occasion, if I can correctly remember, submission was that if they are working in sanctioned posts, it can be allowed. Today is the date of hearing,
My lord.
right?
Yes.
Are you all having any other dates of hearing?
No, my lord, but they are not working against a substantive post. For the central government school, my lord, we don't have data. We can ask the students or the candidates to provide data
Yes,
given
yes.
by the school. For the state government schools, my lord, a list has been provided by the government of West Bengal to the
Alright,
commission.
alright.
This is the list of 850 odd teachers, my lord. All of them are working in a contractual on a contractual basis against a sanction post, and each of those teachers, my lord, your lordship, if your lordship can take that list, each of those teachers have a teacher code which the petitioners do not possess.
Teacher code is
Given
allotted by whom?
by the government, my lord, to a teacher who is working in a substantive post either permanently or contractually.
They are not appointed by the government. They are appointed by the managing committee of the school, right? And submission is that it is only they that who are teaching. Otherwise, there are no other teachers.
I cannot endorse to that, accept or deny that submission, my lord, but the school even has not certified whether that post is substantive or not. If your lordship can take page number 3 of the supplementary affidavit, the school is saying that he is working sincerely, he is working
it has been
diligently.
stated specifically
and he
in
is
the
the
substantive post.
A single sanction post assigned to him.
Yes.
What more do you want?
In everywhere I have
the
annexed it.
post we sanctioned by the government, my lord. The school,
Yes, yes.
in
Yes.
my humble
it's not the
submission,
government. School is not sanctioning.
The
It's
school-
sanction post.
school cannot
Is
certify, my lord.
anyone sanctioning?
In similar matters, my lord, direction was given to implead respective DIs. In those matters, my lord, we have already filed reports of part-time teacher. My learned senior was appearing for petitioners in those matters as well.
Results might be out. One
So, my
thing,
lord,
my lord, may I put this to your lordship?
Until and unless the government certifies that
Application, let SSC consider at the time of application. SSC is the authority. They can inquire by a phone call from the DI whether I am in a sanction post or from the school. We are candidates, my lord.
the onus lies upon the petitioners, my
Yes,
lord,
that
to
is
prove
why, my lord, I have
to-
produced the
You
documents.
have not implemented the district inspector of schools as party.
they are not
My
there.
lord, not this, because, my lord, my grievance is against all the
I
grievances.
understand, but you knew that this will be the issue whether you are teaching in a
Lord,
substantive.
initially, this was not the issue, my lord. Initially, only the issue.
Last such order, my lord, was passed on 14th of October.
Thereafter, the issue, no, all the DI should be made as a party, everything. Initially, this was not the issue. If your lordship so desires, I can implead all the DIs as party.
Not all the are they from
Yes, my different district. My lord, the school and higher secondary council are also then important.
Yes, because they will have the data as to whether you are working
Yes,
in
my
a
lord,
substantive post or not.
I will implead, my lord. Then only one thing, if the results are published today, tomorrow, then, my lord, if the matter is taken up on Tuesday, a window may be open for me. If I am success, then the marks should be
Your
given.
advertisement, had it been specifically mentioned what this substantive post means, then many litigations could have been avoided.
My lord.
You have mentioned in a substantive post as permanent or contractual. What does this substantive mean?
The substantive post, we have explained it in our report
You
that it
in
means
report, it should have been there in the advertisement
that
itself.
any post, my lord, which has the sanction of the finance department of the government is a substantive post.
Right.
If a school
Only
for
one
certain exigency,
over here could have sufficed. A lot of litigations could have been avoided. But see, they say that they are substantive post holders and this
My school is
certified
saying
the
so.
sanctioned post. You are not sure because you do
Look,
not have the data.
as per our data, my lord, it is not a sanction. We have
Yes.
the data of all the sanction
Sir, all
posts
the
given by
para
the.
teachers and everything.
This you say you got this from the DIs?
We got this from the Commissioner of School Education, my lord, who has compiled the data for every district, and from the
And the data was available, the records and the figures were available from the concerned district inspector of schools?
Commissioner of School Education, after taking data from concerned
DIs.
district inspectors, has forwarded the compiled data to us.
Give a copy to him also so that he gets to know and find out if any of the petitioners over here falls under this list or not. If not, did you
So
check?
far as our it is not there.
None?
No.
No, there is number of writ petitions have been filed.
Right,
and
please
pending.
come. The petitioners claim to be teaching in all in higher secondary or secondary also?
My lord, 9, 10 and 11, 12.
Actually, in the secondary and higher secondary schools.
Single sanction.
Stop. They intend to participate in the recruitment
আমার তোর বই নিয়েছি
process of teachers in terms of the advertisement published on 29th May 2025 by the School Education Department Secondary Branch.
না অনেক জায়গাতে
The petitioners
স্যাংশন নিয়ে নেয় কিন্তু ডিআই থেকে অ্যাপ্রুভাল নেয় না এই নিয়ে মামলা হয় না
অ্যাপয়েন্টমেন্ট পোস্ট স্যাংশন
pray for
পোস্ট স্যাংশনটারই অ্যাপ্রুভাল লাগবে তো নাহলে তো
এটা
অ্যাপয়েন্টমেন্ট
দেবে কমই যায়
grant of 10 marks on account of prior teaching experience. Submission is that the petitioners are serving as teachers in substantive posts on part-time basis. Certificate from the schools where the petitioners are teaching are annexed to the supplementary affidavit filed by the petitioners in court today. Stop. It has been submitted that tomorrow, that is 7th November 2025, is the date fixed for declaration of the results of the written examination. Stop.
কালকে বেরোবো তো
Petitioners apprehend that they may not be allotted the 10 marks.
না করে দিই
Stop. Prayer has been made to direct the respondents to consider their case for grant of 10 marks. Yes,
only one submission is recorded that the results will be published tomorrow, my lord.
written examination results will be published tomorrow.
My lord, will kindly not record that. This is our instruction verbal. We don't have a written instruction, and this is something, my lord, which is beyond the purview of the.
Because all along submission is being made in other matters also that tomorrow is the date of declaration of the result. It's not so.
It is, but we do not have the written to give it to the court. If for some reason.
It is his submission that I have recorded.
My lord,
That
okay.
results will be published.
My lord, my lord.
Next,
এটা কোন নোটিশ আছে
learned advocate representing the School Service Commission relies upon a list prepared from the data collected from the office of the Commissioner of School Education, disclosing the schools with their sanctioned strength. Stop. It is the submission of the Commission that the petitioners are not serving in any substantive post and will not be entitled for the marks for past for teaching experience, prior teaching experience. ঠিক আছে. Paragraph. It appears from the cause title of the writ petition that the district inspector of schools where the under whose jurisdiction the petitioners are serving have not been impleted as party respondents in the instant writ petition. Stop. To ascertain as to whether the petitioners are teaching in any substantive post or not, their presence will be required. Stop. Paragraph. In view of the above, the learned advocate of the petitioners is granted leave to implead the respective district inspector of schools as party respondents in the instant writ petition and serve a copy of the writ petition in the office of the learned government pleader. Stop. Learned advocate representing the state respondents shall come ready with proper data as to whether the schools where the petitioners claim to be serving are substantive post or not.
DI and West Bengal Council of Higher Secondary Education.
আচ্ছা, যেখানে DI বললাম তার সাথে and the West Bengal Council of Higher Secondary Education. আচ্ছা. Let copy of the writ petition be also served in the office of the Council of Higher Secondary Education. Stop. Learned advocate for the Council shall also come ready with necessary instruction on the adjourned date. The released on 24th of November.
My lord,
Stop.
any day before that, my lord, if the results, interview, everything will be over by that time because
You think it will be done so soon?
yes, my lord, there's a time schedule published in the advertisement because within 31st
Where is
December.
the schedule? 31st of December is
No,
December is still
everything
some
has
time
be
to
com-
go.
Schedule
Page
is that, my
74.
lord? Page 74.
But 24th November is
Do one
publication of panel.
Do one thing,
70
make it on 17th of November.
এটা এখনো
ঠিক আছে? আর একটা জিনিস,
ফার্স্ট উইক অফ নভেম্বর
the fate of
এটা আমি চিনি।
the instant writ petition regarding allotment of 10 marks meant for prior teaching experience shall abide by the result of the writ petition.
My lord, I filed my court fees and affidavit of service.
আচ্ছা,
ওইগুলো
court
বলো।
fees and affidavit of service,
দিও না।
deficit court fees.
আমি তোকে দিয়ে দেবো।
ও আচ্ছা, তাহলে আমরা স্ক্যান করে দিই।
হ্যাঁ, স্ক্যান করে পাঠিয়ে দেবো।
বলছি যে
The writ petition কোথায় দেবে?
বলছি বাকি
কোথাও যদি miss হয়,
সতেরো তারিখে
affidavit of service করে দেবে,
স্যার ভাবছেন আগে যদি চলে আসে তাহলে আগে চলে
এটা ফেরত দিয়ে দিন।
বলবো 17
ঠিক আছে।
Who is appearing for the state in this matter?
ঐশী
It's this,
ভাস্করদা পেরো।
আমি দিন
you are appearing with,
My lord, I am appearing on behalf of state, my lord.
why is the name of Mr. Shishana Bandyopadhyay, Shondip Dasgupta, Mahima Kolaya, Niket Oja, who has submitted this slip? You?
স্কুল এজেন্ট
Bandyopadhyay is also appearing on behalf of the state. He is on his leg.
I do not know, 2 slips have come in.
But the difficulty is, my lord, perhaps the department has briefed these, my lord, Mr.
The court does not have any
No,
objection.
I am just assisting. I do not
In that
take a
case,
decision.
all the names are to be recorded.
Perhaps, my lord. Perhaps. I am not for the state, my lord, to assist.
My lord, only my name and Subhojit Chattopadhyay, he is appearing on behalf of state, my lord.
But the others perhaps will be the department. I do not know.
আর কোনো ডিপার্টমেন্ট
Department means the department will contact through the LR or the GP.
But I cannot assist, my lord.
Vimal Sahi and Shubhajit Chaudhary, do not give this.
deeply over. My lord, only one thing since
Deeply obliged, my lord.
is appearing, my lord, instead of serving the government pleader because
can
he
serve
is an
him also.
advocate,
Yes,
my
yes,
lord,
you can.
let them because the government
আছে.
office will not.
All right.
My lord, deeply over.
My I am for the state respondent. I am for the petitioner also.
Yes.
Matter related to the completion of appointment.
But I have a preliminary objection in this writ petition.
Maintainability?
No, not maintainability. Dissent order is passed in 2014 and writ petition filed in 2025.
That means the prayer of the petitioner is to dismissed?
No.
Rejected?
Prayer is already rejected by the authority.
Rejected.
Rejected 2014 and challenged in 2025.
Yes.
Petitioner's father was died, lordship, in the year of 2008.
Yes.
At the relevant point of time, petitioner's son was minor.
Right.
And thereafter, lordship, mother was accepted the pension and sons makes the application before the authority, lordship, in the year of 2013.
Hmm.
And thereafter, lordship, school authority and as well as the school authority forwarded the petitioner name.
3rd of April 2014, I can see from your list of dates that the DI rejected the prayer of the petitioner.
Petitioner. On the ground of lordship, kindly see
Page.
page lordship 7.
Page?
Page 7, lordship, in the writ petition, lordship.
7. Where is the annexure?
My lord, page 37.
Page lordship
37.
37. P10.
Yes.
Lordship. View was published in the year of 2009, lordship. And here the petitioner father's lordship was died in the year of 2008. 11 months back. And on that ground, his application was rejected.
Right.
Thereafter, lordship, he further make the application with different authority, lordship. And
Different authority?
yes, lordship. commissioners of schools as well as the CM and as well as the education ministry also.
All right.
But they did not care about, and thereafter,
So
Lordship,
I send it to the CM to take care?
not necessary, Lordship.
Not necessary. To where do I send? To
Quite
the
of
PM?
Lordship, education minister also involved, Lordship. Petitioner personally, Lordship forwarded the letter. I am not forwarded.
Yes.
And
I send it to the PM in that case.
not that.
Then who do I send it to?
Lordship, due to extremely stringency of the financial condition, Lordship.
And now the finance is all right?
Not that, Lordship.
Not? So why has he come? After 10 years? Please come.
Not a single line in the writ petition has been stated, and my lord, I am
Petition
relied upon the judgment of the
compassionate
Piali Shah.
appointment.
Lordship,
Stop.
Lordship, in the
It
similar
appears that the
circumstance, Lordship,
teacher
kindly 1 minute, Lordship.
died in harness on 29th February 2008. Stop. The widow of the teacher is already receiving pension. Stop. The son of the teacher was a minor when his father expired. Stop. After attaining majority, he filed application. Tell me if factually it goes wrong.
Yes.
Father, কি বললাম? Application seeking compassionate appointment, which stood rejected by the District Inspector of Schools, Secondary Education, South 24 Parganas on 3rd April 2014.
Yes.
Stop. Challenging the same, the instant writ petition has been filed on 22nd August 2025. Stop. Submission is that the application of the petitioner was not considered in accordance with law. Stop. The government order, which was considered for rejecting the case of the petitioner, was not in existence at the time of death of the employee.
Yes.
Prayer has been made to reconsider the prayer of the petitioner. Paragraph. Learned advocate representing the state respondents opposes the prayer of the petitioner. Stop. It has been submitted that the writ petition has been filed more than 10 years after the prayer of the petitioner stood rejected. Stop. There is no explanation mentioned in the body of the writ petition justifying the delay in approaching the court. Paragraph. I have heard the submissions made on behalf of both the parties and have perused the materials annexed to the writ petition. Stop. Admittedly, it appears that the employee expired in February 2008 and the petitioner was a minor at that point of time. Stop. There is hardly any provision in service jurisprudence which permits reservation of vacancies for being filled up when the heir of the deceased attains majority. Stop. Paragraph here. The case of the son of the deceased employee stood rejected in 2014. Stop. The petitioner ought to have proceeded with the matter diligently to press his case. Stop. The petitioner waited for more than a decade to approach the court. Stop. At such a belated point of time, there is no scope to show any compassion to the heir of the deceased. Stop. Compassionate appointment is meant to tide over the immediate financial crisis faced by the family of the breadwinner. Stop. The court is not inclined to exercise jurisdiction in the matter. Stop. The claim of the petitioner appears to be hopelessly time-barred. The writ petition fails and is accordingly dismissed.
Lordship, in the similar circumstances, Lordship, coordinate bench passed that type of order, Lordship.
Next.
And to consider the compassionate appointment.
Would I have for the petitioner?
Yes.
Or I appear for the commission.
The matter, my lord, where petitioner, my lord, for petitioner, my lord, appeared, my lord, second SLST 2020.
State is there?
Yes. Second SLST 2025.
Now what has happened, my lord, kindly come to my lord. First of all, 116 of the writ petition,
Yes.
where the rules, my lord, says, my lord, for experience qualification, there is 10 marks is allotted. And kindly
Yes.
come to middle B portion. Prior
Yes.
teaching experience 10 at secondary level in government or government aided or government sponsored school calculated on the basis of 2 marks for each year in the service in a substances post as permanent or contractual. Now kindly see petitioner are the permanent teacher, they are serving as a permanent teacher. Now my
Where
lord,
they are serving in government schools?
yes,
Government sponsored?
yes. I attach the kindly come to my lord, page 41.
We don't know whether they are substantive.
Page 40, 39. Kindly see. In respect of one petitioner,
Yes.
he participated in this year's Uttar Pradesh Education Services Selection Board conducted selection process, and kindly see page 40. Serial number 171.
Yes.
Jhumpa Mondol. Is selected. She is selected. One of the petitioner. Now, my lord, kindly see the online form which is at page 89. Page 89. At the time of filling up online form, there is a stipulation or guideline that are you working as assistant teacher in any aided and sponsored school under West Bengal government? That's why petitioner could not fill up the column. Now petitioner, my lord, seeking, my lord, additional state marks because, my lord, the honorable coordinate bench of this honorable court on, my lord, page 120 on 23rd September 2025.
Page 120.
120.
Yes.
Regarding, my lord, central school teacher, a direction was given upon this school service commission to allot additional qualification marks on this similar fashion, my lord. Petitioner seeking similar relief. And kindly see, my lord, yesterday, my lord, on 4th November, my lord, 2025, the school service commission published a list asking the candidates
For hearing.
for hearing. And kindly see, my lord, the serial number 8. This is a Shirsho Ghosh matter, that is page 120. I attach the order copy. That is my case. We are serving as a permanent teacher, and the online application is saying otherwise.
There are 4 teachers.
Yes.
And all are serving outside the state.
Yes.
Yes, please.
I mean, it appears that he has not filled up the form, the requisite column. He himself admits.
No, he could not have.
Could not, because in the West.
Just wait, you've placed your case.
The year of joining and experience has to be indicated, as per the brochure. Please come to the brochure.
Listen, Mr. Bandyopadhyay, Mr. Banerjee, the last day, that means on 3rd. Yes, Mr. Bhattacharya.
Date of initial
last
joining.
date, that means on Tuesday, this bench passed order. Your juniors were there. And today is the date of hearing. The court was intimated. They have been, one was there, permission was given to go and appear. Right? Can similar order be passed here?
Can they appear today? I'll inform.
Let me
They are
inquire.
serving well outside state.
They are serving outside the state.
The difficulty I'll indicate to you, Lordship. The examination was held in the month of. Today, after Shirsho Ghosh, page 120, is 23rd.
These matters are coming up. I can understand.
Milord, with most humble respect, they are all fence sitters. Past, and thereafter, since the commission is now calling them, now, Milord, a person working in UP, we don't have any records pertaining to their substantive
You
appointment.
have not mentioned that it has to be within the state of West Bengal.
Milord,
Right.
Milord,
So these loopholes are there.
Again, Milord, no clarification. Milord, we had an outer limit to fill up the forms and last day. Milord, though, Milord, technically, this sort of a matter, it's very difficult to oppose. But kindly visualize.
What is the window that you all are thinking of? Or you can think of these type of candidates. Yes, come.
We'll come back at 1 o'clock.
Yes.
Come back. I'll talk to the. Instead of
Yes, imposing something upon you all it
Well,
cannot
let
be
us have a
complied
word
with.
the-
Yes, yes.
Well, we'll come back at one.
Right. And keep this in mind that these
Yeah, this is
candidates,
what is passing through my lord's mind, you know, I also indicate.
and not only this, similar orders have been passed and these candidates stay outside.
Similar orders, on passing of similar orders, Milord, that has prompted them. The promptitude is now, Milord, not in the month of September when the
You all
exam
did
is
not
or in
challenge
July.
the order. You all did not challenge, and the division bench, in fact, modified the order and permitted
To an
fix the
extent.
date.
Yes.
So in that case, let the precedent be followed, and you all take instruction and come back, keeping this in mind that these candidates are from outside. 1, 5 or 10 before recess.
Yes, yes. Get from it.
Item 5 to 12.
For the state. Well, my lord, I am for the state.
Item number 12. Sitting and gossiping and your matter is being called on. Which year? This year. Why is the pension not being issued? No, why is an application required to be made? Why is the pension not being issued? There must be some reason. Yes, state, what is the instruction?
My lord, I do not have the instruction with me now, my lord. I will.
This was served in September. Why is the instruction not there?
I will bring the instruction on the next date, my
Why?
lord. I apologize, my lord.
It's not a matter of apologizing. Why is the instruction not there?
My lord,
You forgot to take the instruction.
No, my lord. I call them for the instruction, but due to there is a vacation, long vacation, my lord. That's why I think.
Vacation. It's your vacation, not their vacation.
My lord,
It was served long before the vacation.
my lord, within 1 day I will take the instruction, my lord.
You
Within
couldn't
1
take it for 2 months.
My lord,
And then
within
back
1 day, my.
You say you'll take it. Please come. The petitioner claims to be a retired teacher, not getting his pension. Staff learned advocate representing the state respondents is directed to take instruction as to why the pension of the petitioner is not being released. Stop. Released 12th November.
Deeply obliged, my lord.
Number 13. I was a statement.
Was this matter in the combined list?
The matter is for the enhancement of the salary on going to the higher education. The petitioner completed the master degree.
All right.
And the one instruction is there, my lord.
Please give. Yes. Let me give.
Yes.
Show me your instruction, please.
This is the instruction from the district inspector of school, my lord.
The petitioner seeks higher scale of pay on account of enhancement of his educational qualification.
Yeah, my lord.
Stop. According to the District Inspector of Schools within bracket Secondary Education, North 24 Parganas, the petitioner would not be entitled to the higher scale of pay. Stop. Paragraph. None appears on behalf of the petitioner at the time of call. Release the matter on 12th November 2025.
Yes.
Yes, next. Instruction written with the records.
Item number 15.
Yes.
Petitioner's husband died on in the year 2017. Submitted prayer accordingly for dying. In the year 2023, her petitioner was not considered, so she filed a petition. This Honorable Court passed order on 4 September, page number 5.
Yes.
After that, from primary to secondary DI, her candidature was only forwarded, and after that it has been pending before the School Service Commission. Since 6 months already over, no action is taken.
Who's for the state?
আপনি কার আপনাকে আগে না ঠিক আছে লেখা আছে যে
Who's for the state? Somebody was there for the state on the last occasion. You were not present. Inquire and come back. I'm passing it over.
My lord, only one thing, the presence of the board will also be necessary, but the board is not a party.
Board is not a party.
No. Vacancies will now be coming from the board. We approach the board for vacancies.
Alja, please come.
State part is over. They have sent the name to the commission. We have approached the board. We have not yet received anything.
The petitioner seeks compassionate appointment. Stop. It appears that the council, that the Purbo Mednipur District Primary School Council forwarded the name of the petitioner for appointment of clerk of any secondary or higher secondary school in the general category. Stop. Next. The list of vacancy is required to be forwarded by the West Bengal Board of Secondary Education. Stop. Next. It appears from the cause title of the writ petition that the board has not been impleaded as party respondent in the instant writ petition. Stop. Leave is granted to the advocate on record of the petitioner to implead the West Bengal Board of Secondary Education as party respondent in the instant writ petition and serve a copy of the writ petition on the added respondent. Stop. Release the matter for further consideration on 18th November 2025. Stop. Learned advocate representing the board shall come ready with instruction specifying the schools where vacancy is available for appointment of the petitioner on compassionate ground. Next.
Obliged.
Let notice also be served on the learned advocate representing the state respondents, communicating the order of the court.
My lord, I am for the state advocate one.
Gratuity, madam, interest on delayed payment of gratuity. Revised gratuity. As per ROPA 19. 2009. 2019.
Yes.
ROPA 2019. Only gratuity. Disposed.
I am for the state, my lord.
Gratuity.
Yes.
Yes.
Grateful, my lord.
Single people.
I am for the state, my lord.
Only gratuity and not pension. Yes.
Number 19.
দুটো পিপিও দিয়েছে।
From the next date of retirement, because when the petition retired on 14th of February 2020.
Yes.
For 19, my lord, ROPA is affected from 14th of February 2020.
Yes, yes.
From next date of retirement.
I am for the state.
28th of January 2020. Revised. That one.
It's September 2019. PPO date.
Disposed.
18 January 2021.
Item 21.
Gratuity only.
Gratuity. Revised. 23rd March 2020. Revised.
Disposed.
Revised. Staff single.
The only gratuity. Disposed. Yes.
Number 25.
I am for the state. স্যার আপনি এদিকে চলে আসুন, আপনার কিছু বলার নেই।
Yes.
My lord, I am for the petitioner. My lord, I participated in the states level selection process, my lord, 9, 10, 11, 12, my lord, 2016. Now, 24th June 2020, my lord, I came to know about the order, my lord, passed on
Are all the parties represented?
board, my lord, he was informed, and I had a talk with, my lord, Mrs. Bhattacharjee, who normally represents, my lord, board. My lord, I informed her, my lord.
All right, you are there with instructions?
Yes, my lord, I took part, my lord, I repeat, I took part in the selection process, my lord, comments, my lord, 2016. Sorry, my lord.
2016.
Yes, 24th June 2022, my lord, a batch of writ petitions, my lord, came to be considered by his lordship, as his lordship then was, Justice Abhijit Gangopathy. His lordship was kind enough to pass an order directing the commission, my lord, that in compliance of the Rule 12.5 and 12.6, my lord, that the application of marks of the wetlisted candidates and my lord, the other persons, my lord, to be published. From that, my lord, I came to know about my position. The person concerned, I was a victim, my lord, of a, my lord, rank jumping, and despite being armed with the eligibility and qualifications, my lord, I was, my lord, thrown out from the zone of consideration. As a result whereof, my lord, the appointment, the commission was directed to consider, and ultimately commission, my lord, was kind enough, my lord, to grant, my lord, the recommendation as well as the approval appointment of there is there. Now, my lord, thereafter, my lord, an intra-court appeal was preferred. My lord, an intra-court appeal was referred before your lordship's court, and my lord, the honorable division bench, my lord, was kind enough, my lord, to affirm the judgment of the Justice Gangopadhyay, my lord, the honorable single bench, and not only that,
What
my
do you
lord,
want over here? You want 10 marks.
no, I want 10 marks because, my lord, here my case is that, my lord, I filed a review application. My lord, your lordship knows, my lord, the new rule 2025, my lord, was challenged. My lord, the question of constitutionality was affirmed by the division bench, single bench, as well as the honorable Supreme Court. In view of such position, my lord, I was aggrieved. I have not questioned, my lord, the rule. I said the person, my lord, by reason of whose action, my lord, I was thrown out from the consideration. This gentleman, my lord, will get, my lord, 10 marks. I will not get 10 marks, number one. I made a representation.
Despite recommendation, you were not provided with the job.
I have only crossed, my lord, 3 years on the date of interview if I am selected in the selection process. I made a representation, my lord. I made a review application before Justice Division Bench presided by Justice Shane. The order of the Honorable Division Bench. The Honorable Division Bench said, my lord, that my lord, that review application, whether, my lord, I am entitled. My respectful submission, my lord, before your lordship, I have 3-4 submissions to make. Number one, the term experience, my lord, must be, my lord, referred in the to the context that I have gained experience. The secondary teachers, my lord, will also get advantage of having 10 marks, my lord, who had rendered service in the school, my lord, but did not have any experience to impart training, my lord, in the higher secondary school. Number one. Number two, my lord, the contractual employees also will get as per rule. I do not have any objection to that. But question is, my lord, by reason of, my lord, the illegal action and the discrimination, I was thrown out from the consideration. Whether, my lord, my personal right can be compromised in the context of Article 14. Yes. My lord, the question today, my lord, before your lordship is this: I made a representation, and Justice Shane's order, my lord, in the review application, may I, my lord, have the liberty to read for my lord's kind attention to this order. If your lordship permits me, my lord, to read.
1 minute. You have got 3 years experience that you'll get 6 marks.
My lord, 2 years and at the date of interview, if I have already selected, if I am selected, my lord, by them, my lord, then my 2 marks, I do not know, because my representation has not been considered. Today, before your lordship, my respectful submission is this, that since I was, my lord, thrown out from the zone of consideration by reason of the discrimination, which
Then
has been
let
affirmed.
representation be considered by
And
the
my lord,
authority.
kindly, my lord,
Let them
this
take a
part will,
decision.
but kindly observe that this part will be considered, my lord, before the interview takes place. And my lord, kindly sees the Honorable Division Bench order, my lord. Kindly sees, my lord, presided over by Justice Chakraborty. Just check it to them. Okay, there. তোমার এই নিয়ে ফ্রান্সের কথা বলবো। এটা কি রাজ্যকে দিচ্ছি না কিছু।
কেন দেবে না কেন? কেন দেবে না কেন?
কাউকে দিচ্ছি না।
আমাদেরকে এক্সপাঞ্জ করে দাও 1247।
আচ্ছা, ওকে দেবো। দিয়ে দিয়েছো।
কপি দেবে।
May I read for my lord? Page 7. In the present case, the appellant joined on 30th January 2025, and prior to the first date of July 2025, he was able to complete about 5 months of service, and that as such, the deficiencies toward the grant of incremental benefit is of about a month. Had he been allowed to join on the basis of the first recommendation, he would have completed 6 months of service prior to the first day of July 2025. The appellant did not urge any issue of malafide, but the delay had occurred is not attributable to him, and he cannot be made to suffer for the laches on the part of the respondent. Such delay is neither insurmountable nor inordinate. Equity regards as done, which should have been done. In such circumstances and balancing the equities among the parties, we are of the opinion that the incremental benefits cannot be scuttled, and the deficiency in service towards grant of...
This is only regarding incremental benefit, the ratio you want to take down.
Number one.
I understand.
Number two, my lord, subject to correction, my lord. Milord, since the right was recognized by the single bench or the division bench, reference point is my empanelment of the panel, and I was discriminated. If law is everything is in reference to context, the context emanates its journey, Milord, commences its journey from, Milord, the empanelment. And the gentleman, Milord, by reason of whose existence, Milord, I was discriminated, he will get 10 marks.
Empanelment was made in
2016, panel expired 2020. And Justice Gangopadhyay's order way back in 24 June 2022, I came to know about the existence. I made a detailed representation to the commission in terms of Justice Shane's order, Milord.
where is that?
Milord, kindly see Justice Shane's order first. 103.
Show me your representation.
Yes. This is, Milord, page 105. The undersigned had participated in the state level selection test for recruitment such and such in short. However, in an unfortunate turn of events, the undersigned fell short of appointment.
Read out, it's a big one.
Yes, last. Milord, kindly cease.
Let me hear the commission stand.
Milord, only Milord, only one 108. The undersigned was not a party in the WPA number such and such and MAT number such and such. However, in the proceedings where the rules of 2025 were challenged, none of the parties argued the eligibility of candidates such as the undersigned who were appointed through the orders passed by the Honorable High Court to avail the benefit of gaining marks on account of prior teaching experience from the date of their appointment, praying for equal treatment with the other untainted who would get the benefit prior teaching experience, and for seeking clarification to that effect, the undersigned preferred a review application. Next, before the Honorable Division Bench, such and such. The said review application was ultimately disposed of by an order dated 24 September 2025. Whether the Commission would give a relaxation to the writ petitioner based on the observation dated 24/8/2023 would be for the Commission to decide. In the said conspectus of the facts.
It is still undecided.
And Milord, number one, I must point it out, otherwise I'll be failing in duty. Milord, the Justice Gangopadhyay's order, while Milord modified by the division bench, Milord, it says that it will not create any precedent in the future events. But this was in the context of Rule 12.5, Rule 12.6. Today, Milord, that rule has gone into oblivion. Now, Milord, today, Milord, the new rule has come. I am only seeking benefit by Milord, by making a prayer to your Lordship. The term experience must be relevant to the context.
I have followed it, yes.
Milord, firstly, Milord, no orders passed by the Honorable Court in the single bench or the division bench in the petitioner's case, Milord, said that the appointment made thereof will have any effect prior to the date of appointment. It is 2022 when the recommendation was made, 2022 the appointment was made. And
no, the recommendation was made earlier, 2016 it says.
No,
2016 I was empaneled.
Milord, empanelment gives no right. Milord, it is only in 2022. Milord, will kindly see, Milord. I just page 39.
But the recommendation and everything came after she approached court and got orders and everything.
Milord,
Court's order.
experience cannot be notional.
Yes, I understand.
Experience cannot be notional. Milord, we cannot consider a representation, Milord. This is about the laws which is there, which guiding us, Milord. Even if there is a direction to consider, we will not be able to go beyond what is the rule speaks of.
May I answer to this?
Yes, please.
Milord, Article 14, Milord, is a fundamental right. There cannot be estoppel and waiver, Milord, against the law. Milord, I said, Milord, my reference point, Milord, question is, today, the 24/6/2022 order, if your Lordship kindly takes pen to look into it, Justice Gangopadhyay had passed this order, Milord, in the context of Rule 12.5 and Rule 12.6, which is incumbent upon the Commission to publish the result. They did not do so. So there was no fault attributable to me.
Tell me one thing.
No, Milord, Justice Shane has directed them to consider, Milord. Kindly please, kindly.
Consider.
Huh?
To consider.
To consider my case.
Yes, and that has not been
No,
considered.
no. Unless I get to know the mind of the commission cannot say, Milord, it is a question of not only an Article 14, it is a clear embodiment of constitutional morality, Milord, embodied in Article 14. It is a fundamental right to be.
See, before Justice Sen, this experience part under.
Yes, I argued, Milord. Kindly seize the order, Milord. I am extremely grateful, Milord. 103. Mr. Basu at this stage, Milord kindly says, Mr. Basu at this stage has submitted that the candidate would complete 3 years on the date of interview as she was appointed in terms of the order by a coordinate bench. He has drawn our attention 4, 5, 6 of the said order. However, the rule 2016 have been replaced by the such and such. Whether the commission,
but this order was passed on 24th of September. Any time limit given?
no, Millard, but Millard, there must be a reasonable action, Millard. Even if the time is not given, court says.
Please come.
Millard, kindly, the experience 10 years, Millard, I was deprived, Millard.
The
The commission may consider all these things.
petitioner
Not rule. I'm not
is
questioning.
serving as a teacher and has participated in the recruitment process for recruitment of teachers in terms of the notification
And
dated
division bench judgment,
29th May 2025.
Chakraborty's judgment may be considered.
Stop. In the notification, there is a provision for awarding 10 marks for prior teaching experience. Stop. 2 marks, experience upon a semicolon, Devin. 2 marks meant for teaching for each year of service in a substantive post. Stop. The petitioner, paragraph D, participated in an earlier recruitment process of the year 2016 and claims that her name was empaneled for appointment. Stop. The appointment, however, was not provided, and the petitioner had to approach this court on multiple occasions to vindicate her rights. Stop. Next. In the year 2022, the appointment in her favor was made. Stop. The petitioner apprehends that she may not be awarded the full 10 marks meant for prior teaching experience as she has not completed 5 years in service. The petitioner, highlighting her grievances, approached this court and by an order dated 24th September 2025 in page 102, equals delta with the application numbers. An order was passed by the Honorable Division Bench directing the Commission to consider the petitioner's prayer for relaxation based on the observation dated 24th August 2023 for grant of the marks meant for prior experience, prior teaching experience.
At page 40, Millard, kindly.
Stop. Next. The petitioner refers to the ratio, not refers, relies upon the ratio laid down by the Honorable Division Bench on 8th August 2025 in MAT 1247, wherein the court held that as the delay was not attributable to the candidate, he cannot be made to suffer for the laches on the part of the respondents. Paragraph. Specific contention of the petitioner is that she was no way responsible for the delay in issuing the appointment letter in her favor. Stop. She ought to have been issued the appointment letter long back. Stop. The representation before the commission directed to be considered by the Honorable Division Bench. Vide order dated 24th September 2025 is still pending consideration. Stop. Next. Learned advocate representing the commission submits that experience of a candidate cannot be notional. Stop. Mere empanelment does not create any right in favor of the petitioner. Stop. The petitioner was appointed in the year 2022 and her experience will be counted on and from the date of her appointment.
And my lord, no court ever directed to give any notional benefit to.
There is no order passed by any court directing grant of notional benefit to the petitioner in terms of petitioner. Stop. Next.
And my lord, division bench did not direct us to consider the representation. It said that we may, and if we may, then there may be a page 103 bottom, my lord.
Yes. Would be for the commissioner to decide, commission to decide.
Yes.
That means you have to decide. And any such decision may give rise. What does this mean?
Yes. We had only one indulgence, my lord.
No.
We had only one indulgence. My learned friend has just now said, my lord, that there was a notional experience, my lord. My lord, this is, my lord, possibly inappropriate for this case because, my lord, the experience which I have lost, my lord, at that point of time, this rule was not in vogue. I could not anticipate, my lord, that this will come. My lord, the institutional corruption would be deep and all pervasive. This was not, my lord, in my lord,
and my lord, pursuant to that, the entire selection process is gone, my lord. That is also my lord.
Next.
No benefit perhaps
According
cannot
to
be
the
taken.
petitioner, the she could not obtain any order for grant of notional benefit as the petitioner could not have anticipated the 2025 rule specifying grant of marks for the prior teaching experience. Had such a rule been in force, the petitioner could have obtained a necessary order in her favor. Paragraph. Be that as it may, whether the petitioner would be entitled to any additional mark or not on account of her teaching experience has been left open by the Honorable Division Bench to be decided by the Commission. C caps away.
By the end of this month may be decided because the commission.
It has been brought to the notice of the court that the result of the written examination is due to be published shortly and the interview process will start immediately thereafter. It has been submitted that if the marks meant for past teaching experience is not calculated prior to the date of interview, the petitioner may be highly prejudiced. Paragraph. As it is noticed that there is already a direction of the court on 24th September 2025 to consider the prayer for relaxation of the year of teaching, period of teaching by the commission, and the commission was to pass a decision in the matter. Accordingly, without entering into the merit of the claim of the petitioner at this stage, the instant writ petition is disposed of by directing the commission to take a decision in the matter strictly in terms of the direction passed by the court on 24th September 2025 and in line with the orders passed in favor of the petitioner from time to time. The ratio laid down by the Honorable Division Bench on 8th August 2025 in the matter of Shaktipada Pradhan within bracket Supra shall also be taken into consideration by the Commission at the time of consideration of the petitioner's prayer. Stop. A decision shall be taken by the Commission at the earliest, but positively by 26th November 2025. The decision shall be made known to the petitioner immediately thereafter. Stop.
26 November.
Learned advocate for the petitioner is directed to forward copy of the subject representation along with all documents and order passed by the court in her favor or in her support from time to time. Disposed.
I'm deeply obliged.
Is successful this time. Is successful this time. We could not persuade the Honorable Chief Justice in a review.
How it went to the Chief Justice? Just
Yes.
Sen was there.
No,
decided
he
the
filed
matter.
a review from an order in which he was not a party.
That is a judgment presided over by Justice Bhaskar Bhattacharya also.
Right.
Supreme Court.
Next.
Matter relates to interest on gratuity. Interest on gratuity.
Yes.
Interest on gratuity.
Interest on gratuity.
Teaching group D staff.
It will be revised gratuity?
Yes, Lord, revised.
2019 revised gratuity.
Favoring us.
Yes.
27 minutes.
27. Right, item 27, my lord, I made an application for addition of party. I am representing all the
What is your CAN number?
CN1.
1 is there today, but 2 and 3 files.
There are, what I suggest, I have a
Files are not here because
But,
date
yes,
is mentioned.
on this point, there seems to be a couple of matters. Now, I am representing for the untainted persons who in the last time, they thought they are untainted, they don't have to think anything about their life. Now we have faced it. So, once it is decided either way, my lord, we want to say our view because now it's they are seeking to challenge the, my lord, the statute itself, that prior teaching experience 10 marks, at what time it should be given. That's the law point.
Not at what time. The entire thing is ultra vires.
Well, then fine, entire thing cannot be taken because Supreme Court has affirmed it. But in any case,
point has been decided.
No, not at
all
all.
I say today that
Not at all.
in the earlier entire proceedings, because I thought I am an honest, I need not be a part of the proceedings. I lost my job. This time, my lord, I am so apprehensive. That's why I have made an application for addition of party. Either way, lord.
All right. What is the application 2 and 3?
Lordship may add us, keep.
Yes. Addition of party. Untainted candidates addition, you also same thing.
In similar,
You are challenging the rule.
but in my case, my lord, there is no classification of tainted, untainted.
All right. Please place your case.
Yes.
The opposition is there.
Pending, my lord. My lord, other
Yes, my lady, may I just add?
so many petition is pending in same point,
Virtually.
and we also
May I
find
just add
addition of
point
party.
here?
But I was
My date is
suggesting,
6th on
yes.
10.
But that's the reason I was suggesting.
One matter is there before the court.
Yes.
The council is present. Let us start.
My lady, I'm so sorry to interrupt. May I just place one point here, my lady? I appear also for the untainted.
Yes.
My lady, I also appear for the untainted. We are untainted candidates who've taken the exam successfully. But this issue, my lady, of this challenge of this rule has been previously decided by the Calcutta High Court by a division bench, my lady, upholding the rule and security requirement.
Very well.
Giving
Yes,
past experience. So, for
All right.
instance, if you have
My lord, in the
let's take
meantime,
it into
the copies of the can may be given to us also. I'm not praying for an adjournment, but it may be given to us. My lord, we'll know that who are the applicants.
All right.
Receive one can for the commission.
One. Can
And we have received none. State has received none.
Well, according to, I'm sorry.
can one?
No, we have received all.
You've received all. The cans which have not been served upon the parties, please do serve.
Yes, but we may also get a copy so that we know
State can also
that what
be
points
served.
are being taken.
And the board is also there. Board can also be served. All right. Those who have not been served, please do. Yes.
Milord, the point arises, Milord, the background of this, let me tell you, Milord, there was an selection for appointment of teachers in 2016, which was set at not a whole hog by this Honorable High Court, which has been upheld by the Supreme Court. Milord, that's not the issue. Now, the Honorable Supreme Court, Milord, gave them liberty to go for fresh recruitment. Now, in the name of going for fresh recruitment, they have enacted new rules. That rule is under challenge, its virus is under challenge. The virus of these rules was never challenged anywhere before. The court has recorded in division bench, the rules are not being challenged, therefore you are not interfering. Now kindly come to the Milord, the rule. That is at page 32.
Yes.
This is of 29th of May 2025.
Why are you challenging it here in November?
No, the petitions are pending before this court for some time.
There are petitions pending, but you have not challenged it.
Yes, yes. No,
Your-
you mean
October.
Milord, several persons have not filed this petition challenging the virus of the rule. This is one of such petitions.
In November.
Yes. Anyway, but in November doesn't matter. That the challenging of virus does not depend on the particular time. They kindly see what is these rules? These rules are framed in by virtue of Section 17 of the West Bengal School Service Commission Act 1997. I just take your lordship for prima facie satisfaction few of the provisions. The kindly comes to the provision of a selection of vacancy. This is very important. Page 35, Rule 7.
All right. Information regarding vacancies.
Yes. The Commission of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement, vacancy statement of assistant teachers. Therefore, the teachers who are already there, they really are not getting any vacancy for them. And with the approval of the state government, send the same to the board. The board shall, with approval of the state government, send the category wise, so and so. This is the creation of vacancy for fresh selection. Now, while fresh selection is made, then the parties should be treated, at level, at par. All the applicants will have the same benefit of getting the getting entry into the service. Immediately, my lord will find that in these rules, they have created a class amongst the class. Kindly come to the schedule. This is the educational qualification, including professional qualifications for selection of assistant teachers. Therefore, the educational qualifications are at the entry point fixed. Now, kindly come to page 42, Schedule 2. Selection to the post of assistant teacher for class 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience. If this is the fresh recruitment for the fresh vacancies, you are inviting the existing teachers to participate, along with the fresh recruits, fresh graduates, well, fresh entrants. Oral interview and lecture demonstration determined by the Central Commission. Written examination, OMR based 60 marks is common to all. Academics, educational quality common to all. Then kindly come B, prior teaching experience, 10 marks. Therefore, this 10 marks is additional benefit to a particular group who are also equally applying for entry into the same process. Whether this can be done. This would be apparently and patently in violation of Article 14. And then oral interview and lecture demonstration. Now, lecture demonstration of the persons who are allegedly worked, though illegally, and the appointments were set aside by the Honorable Supreme Court declaring void. Another question would come whether they can be given the benefit of that so-called experience. This prior teaching experience 10 marks would violate the Article 14. You are creating a class among class. But this is the violence which I am challenging. Herein before, well, I must say, because I had the occasion to appear, petitions were moved by some group where the Honorable Division Bench says, since the rule is not under challenge, we are not interfering, giving certain reasons. Therefore, now the scope of this court, consider the violence of the challenge, is that matter is still pending. And this is the petition that where I am challenging basically on this ground that you cannot, at the entry point, create a classification. By that, you are trying to give advantage to the persons whose services were terminated. That's the intention. That you can come through back door. Giving 10 marks means all other new entrants will be out at the very threshold. Whether this can be done. This is the point.
Then, has the list of tainted and untainted candidates been published?
According to me, not. According to some, yes. The list which has been published, which I can demonstrate if you permits me from the Supreme Court judgment, is an incomplete list. Again, to protect a particular group. But I am not on that. I say that if the rule goes, then whether tainted, untainted, everything should go. At the threshold, everybody should be put on the same level without giving any additional advantage to X, Y, Z. That should be the compliance of Article 14 and 16 of the Constitution.
Show me the direction of the Honorable Supreme Court regarding this.
Copy ache. No, no, Joshua could either.
সিঙ্গেল বেঞ্চে প্যারা 12 এই জন্য ডিভিশন বেঞ্চ আর বলেনি, সিঙ্গেল বেঞ্চে প্যারা 12 বলা আছে। কেউ তো একটা করেছে রে ভাই, সবই তো একই ব্যাপার।
Give me the number. It can be put on the screen.
Yes.
The officer, the number.
No. Judgment delivered on Supreme Court. 3rd April. কেন হার্ড কপি আনো না? বলি কথা শুনি এনেছি কোথায়? কাজের সময় পাও না এনেছি। এটা রিপোর্ট রয়েছে তো এটা।
2025 INSC 34
বলো ওদের।
2025 INSC 43 দাও 2025 INSC
43 তো করে বলি কাজের সময় ঠিক তৈরি থাকে না, খালি মুখে মুখে তৈরি থাকে। আইপ্যাড থেকে দেখানো এটা রিপোর্ট হয়েছে তো।
হ্যাঁ রিপোর্ট।
তাহলে সেটা দিচ্ছ না কেন?
2025 INSC 437
My lady, may I just make one point while my friend finds the papers, my lady? That the Supreme Court actually ordered the publication of the tainted and untainted lists.
Tainted.
And to publish the list of the
দিয়েছো ওখানে এসছে।
Page 35, Rule 7, you mentioned something regarding the vacancy statement of assistant teachers, right? Your submission is that since the teachers are already in service, the post cannot be treated as vacant. But then the entire selection process stood nullified. Then where is the question of
that stood nullified?
yes,
Therefore,
though
they are
the seats have to be treated as vacant only.
Yes, then how could you give
Yes,
additional 10 marks for teaching experience?
To that teacher.
This is a post for fresh recruitment, fresh graduates at the entry point. Then you come as a fresh graduate, but you cannot have the benefit of 10 marks for teaching experience. I'm not considering whether this was void or not. That means you are creating class amongst.
that I've got.
That
followed.
you cannot do. And
That
at
I've-
the entry point, whether there are Supreme
I
Court
have followed it. I have followed it.
দিয়েছো সবকে? Well, in the meantime, may I read out?
Yes, please read out.
The conclusion of Supreme Court judgment, paragraph 45. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated, and they should be required to refund any salaries or payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. The next paragraph. For candidates not specifically found to be tainted, who are claiming to be untainted, the entire selection process has been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled.
31st October. 31st
However,
December.
the candidates who are already employed need not be asked to refund or restitute any payments made to them. Their services will be terminated. Further, no candidate can be appointed once their entire examination process results have been declared void. Therefore, the Supreme Court is very categorical that all the appointments having declared void, none of them could be appointed. There is no doubt in it.
All right.
And this violation of the rules was never challenged before. The division bench of this court said recorded that since rules are not challenged, we have
Division benches order, please.
This is division benches order.
division.
The division benches order I have handed over, Milord. Arunima Paul.
Convention is ordered now.
Yes,
And
16 July 2025.
10th of July 2025.
So 16 July 2025.
In the matter of
16
July.
Orunima Paul has been placed.
Arunima Paul?
16 July.
It must be the same thing possibly.
16 July.
Same thing. 16th of July. Yes.
No, Milord, just before he.
Let him finish.
No, Milord, the writ petition, in the writ petition from which this appeal arose, Milord, there was a specific prayer, Milord, towards by. And Milord, it was given up before the Honorable Single Judge.
Whatever. Let
us
you will
Milord,
get a chance.
Let us
Yes.
Milord, go by the judgment of the court.
Yes.
Kindly come to page 24.
Yes.
Division bench.
Yes.
The recruitment rules 2025 has not been challenged by any of the appellants. In that background, the division bench order comes. But I know this specifically because I had the privilege of appearing before the division bench and Supreme Court. And then this order was appealed from. Supreme Court did not interfere.
All right.
But the point of why this challenge remains wide open.
All right.
And that's now I'm being conversing before the Lordship.
All right. This is all? Yes, Commission. It is your rule.
Commission.
Your rule that has been
State
challenged.
rule.
My rule, Milord.
State rule. All right.
Yes, Milord.
Yes, state.
Milord, I'll start by submitting that, Milord, the learned advocation has not been served, but I understand the bench wants to, Milord, look into the matter, Milord. So I'll address your Lordship, Milord.
Please do.
Milord,
But the petitioner essentially is challenging the granting of the marks for the prior teaching experience. That is the long and short of the submission.
Yes.
Now, my lord, first your lordship kindly will take, my lord, the other batch of writ petition which was taken. If I may point out a singular paragraph of this honorable single judge's order, which thereafter traveled before the honorable division bench.
Court's order I have handed over.
But the single bench I'm handing over. The same, Arunima Pal. Yes. Single bench for now?
Just 2 minutes.
Now, my lord, my lord, we have the copy of Arunima Pal writ petition also, para 12. We have the copy of the writ petition also, which clearly says in the prayer that the virus of the rules were under challenge.
But then the division bench is.
I'll say why this is coming. I'll say why this is coming. Can you take paragraph 12?
Yes.
Learned senior advocate representing other groups of petitioners at the threshold has submitted that prayer B of the writ petition being WPA 13457 is not pressed, wherein declaration is sought for to the extent that the declaring the rules of 2025 and the recruitment notification dated 30th May 2025 ultra virus. So, that prayer was given up. That is why the honorable single judge did not decide the virus, and that is from where this submission is coming. Now, kindly take the division bench's order. First, my lord, kindly take paragraph 28.
Yes.
In reply, Mr. Bikash Ranjan Bhattacharya, learned senior counsel, has submitted that the writ petitioners are not challenging the virus of the recruitment rules 2025, as their rights are untainted. Rights as untainted candidates are fully secured and has to be tested on the anvil of the judgment of the honorable division bench in paragraph 363 Roman 11 read with paragraph 49 of the judgment of the honorable Supreme Court. Now can I take the prayer of Arunima Pal? Give the prayer of Arunima Pal.
I'll give you.
But I'm giving a soft coin, kindly pardon me, Malad. This is the prayer of Arunima Pal.
All right. What is
Where
the
virus was under check. I'll read, Malad. Prayer B said that in Arunima Pal, a writ of and or in the nature of declaration declaring that the Kolkata Gazette dated 29th May 2025 issued by the office of the Principal Secretary of the Government of West Bengal and the notification dated 30th May 2025 issued by the Commission as being ultra virus to the Constitution of India. Now, my lord, this I believe is also filed from the same chamber that I find from the advocate on record's name, my lord. So, my lord, they are well aware that the virus was under challenge and it was given up by the before the honorable single judge. Though the submission, it's about being aware whether there are averments or not. Now, my lord, kindly takes the constitutionality, whether the state was empowered to introduce 10 marks prior teaching experience or not. Now, my lord, kindly takes paragraph 34 of the judgment. Division bench, page 22.
Yes.
The awarding of 10 marks is an weightage to be given. Weightage to be given on the basis of the experience, and it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher. As rightly pointed out by the learned Advocate General and the learned Senior Counsel, appearing on behalf of the Commission, the appellants writ petitioners are not coming within the purview of the category in whose favor the benefits and concessions has been extended in paragraph 49 of the judgment of the Honorable Supreme Court. They are not candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for the service in any educational institute. General kindly skips over a few lines to the next page from the third line. If we accept the submission of Bikash Ranjan Bhattacharya, learned senior advocate, then for the selection for the same subject, teachers, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision of the eligibility criteria, so and so, then the NCT, that NCT also allows it, is discussed. Then Malad kindly takes towards the bottom of that page, second last line. While the candidates with 45% marks in graduation may be eligible for the same subject a candidate requires to apply under the recruitment rules of 2025, would have to fulfill a criteria of 50%, and both of them, if appointed, may be a teacher for the same subject teaching in different education institutes. This will result in discrimination and a compromise of the quality. The prior teaching experience is an important factor, as experienced teachers may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the appellant. The delay, but this is where, that is why the single judge's paragraph was important. They prayed for it but gave it up. The delay in the recruitment, fresh recruitment, is due to the pending litigations, and when the opportunity for employment is opened by advertisement, it is always open for the authority to decide the eligibility of the other criteria in the academic interest for the benefit of the student. We accept the submission on behalf of the state respondent that there is no specific direction in the order of the Honorable Supreme Court by which the state is obligated only to fill up the declared vacancies of the first SLST 2016. All the orders relating to the issue had directed the fresh recruitment to be carried so and so. Then my lord kindly skips over to the next paragraph. If the government, 35, if the government felt that the experience gained by the candidates is relevant, the court cannot take a different view in judicial review. Similarly, prescribing any age limit for the given post and also deciding to the extent to which any relaxation can be given to the said age limit are essentially so and so. But these are on the other points which has been discussed. Then I am skipping over a few lines. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called arbitrary or irrational. The eligibility criterion in the recruitment rules 2025 is in furtherance to the object of finding the best available talent. The prior teaching experience has been considered by the division bench. It has been held that we are empowered to introduce it, and it is held that the court should not interfere in judicial review when the administration has thought it to be a fit exercise of their discretion, administrative policy. This point, I need not elaborate whether the prayer was there or not, whether it was given up or not. It was prayed, it was given up. As far as the state is concerned, it is issue estoppel. This point has been decided. This order has traveled before the Supreme Court. We have placed in several matters, and all the points are discussed here together because there are many other challenges by several petitioners. All my learned seniors assisted the Honorable Supreme Court. Your Lordship, even assuming that there was no challenge, it's a fresh challenge, fresh batch. Who is ultimately what is the point? The point is, first of all, whether I had the power or not. Secondly, whether it's ultra vires the constitutional scheme, whether it's creating arbitrariness is or not. But the power has been upheld by the division bench, then the Supreme Court, and the fact that it is not arbitrary within the campus of Article 14, that has also been discussed. But Supreme Court, I can copy.
Supreme.
I won't take soft copies.
No,
Yes.
Therefore, this point, your Lordship will kindly not go into any further.
Yes.
Your Lordship will not hear.
May
I will, certainly I will hear.
May I add one point to the government?
Yes.
My lords, may I assist my lady, my lords, by just making 2 or 3 points, my lords, if I may.
Just wait, madam.
Yes, very well.
Paragraph 6, page 4 of this judgment, which may have been placed, could have been placed. Paragraph 6. My learned friend Mr. Vikas Ranjan Bhattacharya appeared and what he argued. Mr. Bhattacharya submitted the finding, observation, directions about order to be strictly followed. That's all right. Mr. Bhattacharya further submitted notification, etc. Then may come. Further submitted that there has been significant change in the rules which would render the present applicant disqualified. It is submitted the prior teaching experience for 10 years was not an eligibility criteria in the earlier notification. Moreover, the percentage mark has been given arbitrarily and otherwise qualified. So these are specifically argued. Please, see by Mr. Bhattacharya further argument. Please come to me at paragraph 24 of this judgment. Page 15. Mr. Bandyopadhyay, is the argument of the government. A commission was justified in awarding, has justified the awarding of 10 marks for prior teaching experience on the ground that it also extended to the teachers who have taught in schools under Kendriya Vidyalaya Sanghan, etc., and training and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach. Pausing here, my lord. Now, what you argued here, because this teaching experience marks, 10 marks, are being given only to those unsuccessful candidates who have failed. It is not so. The teaching experience 10 marks are available to everybody. Even the client applicants,
সেপ্টেম্বরের
if
অর্ডারটা
he has
দেখো
got teaching
রিজেক্ট করে
experience
দিল
in other schools, etc.,
সেপ্টেম্বরের
he
অর্ডারটা
get
এদেরকে কন্টিনিউ করতে
It's
বলেছে
not a class
এবার
within class.
আমার পোস্টটা যে
See,
ভ্যাকেন্ট
without the point, see, the teaching will be given to all who have, not necessarily those who have appeared in earlier first stage and failed. No.
এমনি এখনো জোর নেই
But this is it
যত
wrong.
পয়েন্ট আগে
It
বলছি
will
জোর
not
নেই
confine to the candidates who had succeeded in earlier first and thereafter been disqualified because of others' fault. It will be available to all. It's made clear.
But why will the freshers lose this 10 marks? Why will the freshers lose this 10 marks?
The freshers, if they're teaching experience and applicants of other schools, they will also get
No. Freshers. Fresh candidates
candidates.
not having experience. Why will they lose this opportunity?
They are not best candidates. If they have teaching experience, they can get.
Those who have got teaching experience are not fresh ones.
Experience, why should they include it? That's it. Is the teaching experience, that's what is being argued by Paragraph 24. The teaching experience have been taught in school under Kendriya Vidyalaya, etc. Marks for prior teaching have been provided with appointing experienced teachers. That were experienced teachers, they will get the eligible appointments. What's wrong there?
Why will the fresh candidates not be, or rather lose this 10 marks?
No,
This has been answered.
Why don't you? Because teaching experience is a valuable qualification.
Yes.
Now, all the applicants who can avail of this, provided he has a teaching experience. Now, is it argued that this qualification mark of 10, even for teaching experience, is bad? Or why it is bad? Why it is bad? Can you see paragraph 35?
34 34 also, sir. 34 has answered the point.
35 judgment. And what the court said.
34 court line it answers.
If the government failed, can you see paragraph? If the government failed, that the experience gained by the candidates is relevant. The court
কোনোটাই হার্ড
cannot
কপি আনিস
take
নি
a
তোরা
different view in judicial review.
আরে বুঝেছি কিন্তু তোদের এটা ধরে চললে তো হবে না সবকটা কনসিডার বিপদ হয়ে যাবে
Over it has been all done by expert body. That is also mentioned in the document that these criteria have been fixed by expert body. And why the second interpret with them? Now, my lord asked a question, but I'm happy in my lord. So why 10 months and these will be given for experienced teacher? Answer is that government values experience. And those candidates who have got teaching experience, they should be awarded by districts because you get the teaching experience. That is what was argued. And not can you not come to the paragraph? This is if it has been taken the point, can the court say court cannot take a different view in judicial review? If the court say if the employer thinks that the teaching experience is a valuable asset, for which can be reviewed. It is why it is arbitrary. It is open to all. It is not that had there been teaching experience of only the first level failed should have been given. No, it's just not. Anybody can speak. Like people who have got no teaching experience they have done. People who have got teaching experience they are also will have done. Some people have now these people with full knowledge of this qualification and station mark, have applied for and participated in examination already. Doesn't go that way. They appeared, participated in the examination held in September. Appeared there. And we pulled on it. Now, after having appeared, they're saying that you can just candidate there. Disturb data, sir. Disturb data. On the petitioner, it goes out.
My lords,
I'll show you a document, my lord, of Supreme Court. They have appeared, participated, everything. With knowledge of this. At the time of appearance or the application, they have not taken any objection to this rule, knowing that they don't have anything in details. Try whether I get it. Because the judgments, a large extent cited of Supreme Court, that was modified by that of Supreme Court, I said that has not explained. The judgment 17th April, kindly see that 17th April order. Kindly see. Then I will give you a list of dates.
order.
Supreme Court says that
My lord will kind.
he may not. In this case, Supreme Court accepted the matter. Then the judgment cited by Mr. Subjective was earlier done.
Yes.
Client accept the prayer made in the present application. It relates to assess the details or process and not found to be taken. Subject to the following conditions. First of all, it is all triggered by Supreme Court and Supreme Court is a timetable also. And at the same time, for the fresh recruitment, records and both shall be published before 31st May 2025. Second is very important. Examination and the entire recruitment process shall be completed by 31st December 2020. It's an historical. State government, applicant, appellant, West Bengal, etc. shall file affidavit by 31st May 2025. Enclosing therewith a copy of the advertisement for the place recruitment as well as schedule therefore, so as to ensure compliance of the complete recruitment process. In case advertisement is not submitted, consequences follow. We likewise order the conferring and special like anybody. That's the point. You don't conduct special like anybody. The deputy will be special right. That's what it is. As in conferring a right to an untainted candidate to appear and only a candidate doesn't confer any special right upon them. The same right the best candidate also has. What is the right they don't have? The question of right to apply is different from the qualification marks of it. Criteria for that. They are the same right to apply as the order says that only untended candidates will appear and nobody else. Then Mr. Bhattacharya did to the things. No special right will be given to anybody. No matter fresh recruitment process is concerned, so that anybody can apply. This application is not confined to untended. It's confined to fresh candidates also. But what the order of Supreme Court, what does it get? The fresh candidates will get some advantage. That even though they have no teaching experience, they will get 10 marks. What is this argument now? After we have kindly give us timetable, everything scheduled by Supreme Court. Triggered by Supreme Court. Now we don't after appearing, and it take back this topic. So give me some.
This
Copy
topic
আমার কাছে আছে এটা
আপনি করুন স্যার আমরা দিয়ে দিচ্ছি
Can you take a list of the similar all these relevant facts which should be rejected outright? কোথায় গেল আমার আপনারটা কোথায় গেল দেখুন 29th May, 17th that the order was passed to publish the After written by 31st May, 29 May, application within time. Publish the rules. That is publish the rules, call the website, etc. For appointment to the post or as assistant teacher, etc. And building excellence. This is the equal page. Equal number is given there. Right. 30th of May 2025. Notice issued inviting application for conducting second for the classes 11 to 12 also. In the pursuant to the judgment dated 3rd April passed by the Honorable Supreme Court, stating that the said selection process shall be governed inter alia by the rules 2025, relevant acts and subsequent amendments. Noted that the recruitment process started on 30th of May. Not, can you see the notice where it specifically mentioned that Rule 225 will apply? They have seen that notice, and pursuant to that, they have applied. That please see the notice which is annexed. There is it is shown. I'll show it to you, Lordship. If they finish the list of dates, I'll show it to you, Lordship. Then 16 June, online application for appearance in written
annual day and meeting signed up, otherwise I would want.
Then 14 July, last date of receiving the online application as per schedule, etc. Then 7 July, Rule 25 governing second action was challenged on the ground that 10 marks for teaching experience should not be granted, and the same was dismissed by the Honorable Single Bench on 7 July. That order of should not seen. Mr. Bikajan Bhattacharya argued, he knows better. He's argued noted, he was arguing that giving 10 marks for teaching experience is bad. Same arbitrary void, etc. That I must again point out, because single bench dismissed the petition. Men are on the ground. The main another ground was the untainted candidates. Tainted candidates should be also be allowed to appear in the second examination. But court held, Supreme Court said only the untainted appear. So because no, they say right, only that prohibition of tainted candidates should remain valid, and not on that ground it should be dismissed. Single bench has not specifically given reason why this 10% except his influence is good or bad. Right. From that, they come to the division bench appeal, which has been placed before Lordship. 16 July, writ petitioner being aggrieved by the judgment filed an appeal before division bench, which was also dismissed after hearing the parties, until observing that awarding of 10 marks on the basis of experience is not arbitrary. That paragraph was shown, I can full of it. Then Milord, special SLP was filed. We have got a copy, keep the copy ready. SLP was filed, same was dismissed by the Honorable Supreme Court, not by with reasons. After observing, we find no good ground and reason to interfere with the impugned judgment of the High Court. Can you see the judgment? A Supreme Court, a dismissed collegiator. SLP dismissed. We got a copy, I'm handing what to copy to your Lordship. You ready, good? And with this, we're quoting from that judgment. This is the handing it. Mr. Bhattacharya appeared. He knows this better than me.
Therefore, I know better.
I know better than me.
Unfortunately,
That this had happened. You know that this had happened.
I know what is happening and what is going to happen. Not what
Anyway.
is going to happen. He knows what is going to happen.
With reasons they have been dictated. Then my list of this serial number 7 only come to. Writ petitioner Bhim Kumar Sarkar received his admit card issued by the commission for examination to be held on 14/9. Can you see page 31 of the writ petition? The document annexed in the writ petition. Page 31. I'll throw it up. Page 31 writ petition. Writ petition page 31 দেখো আমারটা কোথায় গেল আমার বিপকে হারিয়ে গেল It is mentioned below what particular examination date is mentioned. Admit card is for that date. And that was for class assistant teacher 11 and 12. That also mentioned. আমাকে না দিলে ভাই এই brief কোন হারিয়ে ফেলে কি করে দেবো বল?
Yes, yes, then
Huh?
I have seen.
Then Milord, he appeared in examination 49 with full knowledge and you can go down. No. Then make the next date. 22nd August. Notice Milord, D can omit D. Notice was issued by the commission permitting the selected and appointed untainted, but not typing mistake, can make it untainted, not untainted. The spelling mistake. Candidates, another 10 days, time was being extended for submitting application. Extended. After Supreme Court order. Then Mirror 9, serial number 9. 7/9/25 written examination by the assistant teachers held of 9 and 10 held. And on 14th September, this is important, a file for the assistant teachers for 11 and 12 was held. And in this petition appeared. Here and got the admit card for that. Read petition ready. Now, read petition, then 14th September, petitioner Bhim Kumar had taken the written examination on the said date and result was awaited. Now, on 31st October, pending that, he made this writ application. And what is first prayer? He the prayer 10%. In the same present petition, have filed a petition challenging Rule 25 on the ground that teaching experience of 10 marks cannot be awarded to the selected untainted candidates. He the prayer A, or the writ petition. That is the ground he has taken. Prayer A. On that ground, cancel. And this has been division bench judgment shared in the face, which has been approved by Supreme Court by giving reasons. And in spite of that, 2 points arises, Milo. Can this petition be allowed to be moved when prima facie there is no case and this order is of division bench judgment is binding on everyone, which approved by Supreme Court. Therefore, no case, prima facie case is made out. Therefore, take it into account that single bench may be pleased to say, what can I do? I have a good deal of sympathy, but I'm bound by judgment of division bench approved by Supreme Court. Second point, the time schedule and this selection process for untainted candidates, etc., has been triggered and fixed by Supreme Court order. Supreme Court has fixed a date. The 31st May is the date by which you must issue the notice inviting application. And further, that process must be completed by 31st December 20. In the middle of that, on 30th October coming, can this selection process after having started, can that be interfered with at this stage? And the time is fixed by Supreme Court. It will delay the selection process.
Yes.
So, this is the now it's in matter which is in the domain of Supreme Court. They are now getting interfered by the Honorable High Court. Just to in my humble submission, in by stricture of Supreme Court. It is not if order is passed, any interim order is made, then that will affect the progress. Secondly, thirdly, I point out, it's about minor discussion, well settled principle. When the recruitment process has started, and on the basis of rules which are known to the appearing petitioner, and on the basis of which he has applied, without mentioning that I'm making the application without prejudice to my right to challenge, etc. Can he, after examination, when results are to be published immediately, very soon, the commission can tell you, can it be allowed, should be entertained by the court at all? This is my first submission. In the court, in its discretion, should be particularly in view of the fact that the matter is fixed by Supreme Court. And they should apply to Supreme Court then, that kindly see the notice of recruitment by paragraph. Notice of recruitment. Notice to recommend that notice here, I taken out. No, no. Lordship in the notice is clearly mentioned, which are quoted in the list of dates, that it is Rule 2025 will apply. Please see me not the part.
Yes, yes, Rule 25 will apply. 25.
Now, Milord, what has been the, apart from on merits also, Milord, no ground has been disclosed. Why this additional teaching experience mark, sorry, a particular mark, 10 or 5, whatever maybe, for a particular kind of experience, teaching experience, which is a valuable asset of the candidate, cannot be given. Fixed by expert body, and division bench said that if they have fixed it, look, nobody has they have not argued that teaching experience is irrelevant matter for the appointment of teachers. If the argument could not be made and has not been made, the teaching experience is an irrelevant consideration for appointment of teachers. I haven't been, nobody can argue that teaching experience is irrelevant consideration for teaching, for teachers. For teachers, is not appointing football players. There I could say the teaching experience 10 months will be given to a football player for being appointed in the team. It is being given to teachers. And teaching experience is valuable qualification. That experience. So this petition will be nipped in the bud. It should not be without entertain at all.
Did I hear you?
Yes.
You?
Yes.
All right.
My lord, there are couple of points which have been taken and that was identical, so I won't be touching the same. All points by Mr. Mitro, my lord. In fact, I also had in my mind, I'm not touching. First, I would address on a very fundamental point of view. Mr. Bhattacharya, in my understanding, is trying to portray a picture of the world where either there black exists or the white exists. In other words, I said metaphorically this part. In other words, the word void, null and void in the Supreme Court's order, it's so clear, so watertight that it cannot be tweaked. Either Supreme Court having declared null and void, does it mean that Supreme Court has also said whatever is also attached with all the candidates minus the tainted? Because well, I'm not appearing for the tainted, so tainted it's done. Kindly look at from this point of view. I do not say that in a particular situations the court cannot declare something to be void, null and void, and the consequence of the same means absolute zero, no experience out of it. It can be. But contrast it with the situations, having said null and void, the same Honorable Supreme Court also said and felt for us, in a sense, saying that who were working somewhere else, they will also be able to resume their duty, number one. In other case, Lordship, kindly take paragraph number 47. Lordship will see the meat path being taken by the Honorable Supreme Court. It's not black or white. Yes, selection process has been found to be illegal, right? Does it necessarily mean that all the fair candidates who have put in labor, who have received money, and who have also, my lord, whatever experience they had, who have done the teaching experiences, does it automatically go from their experience? To that effect, there is a clear answer by the Honorable Supreme Court in paragraph 47. My lord, the copy is there, possibly with your lordships. Kindly take 47.
Supreme Court judgment is not here.
It is.
That's
the main judgment. Mr. Bhattacharya has read out 45. So I am not reading 45. Now kindly see 47. That is the tweak and that's the middle path. And recognition of, I may not use the word sympathy, but that what we suffered is a collateral damage. We are honest. Now that was acknowledged.
And the list I would like to see.
Yes.
the tainted and untainted or something, how this has been
they would
you do not know, commission will get.
So far as we are never been in the list of that. That's for sure. 47, kindly see, some of the Lordship has taken 47. Some of the appointed candidates who do not fall within the category of tainted candidates. So this is the first tweak. May have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies, kindly mark the word, to continue. Well, there is a difference between the words to begin fresh and to continue. And to continue is the recognitions. Yes, we have to no other alternative, but we also recognize that you had a service, and thereafter, kindly see, to continue service with those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. So just like us. Now kindly come to the other point, leaving aside Supreme Court judgment. If I put a question to myself, can prior teaching experience be a criteria? Can you take any professions anywhere, even in our profession also? Experience is an age versus someone who has got the educational qualification. If the authorities feel that, and there are variety of rules and also recognized by the Supreme Court in some judgments also, that having a paper degree is one thing, which is a prerequisite. At the same time, if someone also has in reality an experience of teaching students, giving marks for that, to my understanding, well, this is absolutely valid and legal. Yes, that there could have been a complete block had the Supreme Court, have the Honorable Supreme Court, while referring to judgment, this is a meat path. Just because the word void, that void is in respect of the selection process, not void in respect of the money we have received, not void in respect of the experience we have had. Now that has happened, that is, in my words, it's a middle path. After recognition that we have suffered without being tainted persons. Kindly see, Mala, thereafter the most important word. Further, the period between the termination of their previous employment and their rejoining will not be considered a break in service. So recognition. So if Lordship kindly take one extreme view, that void means zero. So there cannot be a continuation of that. Thereafter, their seniority and other entitlements will be preserved and they will be eligible for increments. So therefore, if I am honest, if I happen to be in a society where unfortunately there was a selector who was corrupt enough and I suffered, so the Honorable Supreme Court recognized my suffering as an honest person and therefore tried to preserve the experiences that I have put in. In other words, if I put one sentence, in other words, the judgment of the Honorable Supreme Court does not say that because we have declared it to be void, that means everything zero. That means all the teaching experiences that we have done, that comes to zero. That is not. Then this continuation seniority would not have come. Now, second point comes, this issue, well, the matter is pending before the Honorable Supreme Court. What I find is that in Orunima SLP, I have the soft copy, page number L, I am reading out the exact portion. Soft copy of the SLP.
Orunima Paul?
The
Yes.
SLP
Not the order. I'm referring to the soft copy of the SLP, my lord. I will hand it over. Page number, yes, page number L. Well, this is one sentence, I just read it out. Further, there was an extra 10 marks for teaching experience in the new rules, which automatically affected the candidates like the petitioners who could not teach due to the fraud played by the State Commission Board.
Grounds are the grounds.
So my respectful submission before your lordship is this. As an honest candidate, I have already suffered. We have already suffered because we live in a society where there is a corruption. Even if we are not corrupt, we lose our job after so many years. After that, now lordship would be not taking the matter just a matter of technicality. Also, lordship would deliver justice to all. As a candidate who have been found to be not tainted, who have served from, my lord, this 2016 recruitment process, and for the system who have lost, and they have lost because of the judgment where seniority has been preserved, money have been preserved. Now state has framed and come up with a rule that this experience, I'm not saying this, any experience, because it's not just us, anybody who has the prior teaching experience, they will get an X marks. Is it really so ultra virus to Article 14? And my respectful submission before your lordship would be, it is not. Kindly have a look at this judgment of the Honorable Supreme Court. This is 2017 11 SCC 421. There, first lordship, kindly take paragraph 16, paragraph 16, paragraph 17, and then paragraph 21. This is, here the word is, well, the weightage for experience. And kindly see on 21, irrespective of the whether weightage was from illegality or legality.
All right, 16, please,
Yes.
please.
Kindly see 16 circumstances, the members of the appellant union are entitled to know the result of the such and such. All that the learned single judge directed was to conclude the process and declare the result after giving such weightage to the past service of the members of the appellant union as the first respondent deemed fit and proper, which the Supreme Court also granted in paragraph 47. Now 17. We do not see any error in the directions given by the learned single judge, and we are of the opinion that the division bench is clearly in error in interfering with the said direction. Now kindly come to 21. The first respondent who was a party to the settlement recorded by High Court in its order dated such and such could not be permitted to raise the question of the enforceability of the settlement. More particularly, when all that the appellant seeks is only weightage for the past service of his members, which the first respondent agreed, in principle, well, I am on principle, to give to similarly situated persons working with other departments. The member of the appellant union have been working with the first respondent for long periods, period varying from person to person. Whether such employment was regular or irregular in law, in a different matter, the fact remains that their service were used by the first respondent. All my respectful submission before your lordship is this: once the Honorable Supreme Court in the main judgment recognized the past service for the honest candidates, framing of a rule by the state, not for honest, for everyone, recognizing the past experience as the teaching is absolutely not violative of Article 14 of the Constitution of India. My lord, I would just conclude by saying, because the points of Arunima, that this point, in fact, my lord, lordship may also think that this is a unique situation, because this is a kind of matter, unlike other matters, once the matter is over, my lord, Supreme Court usually puts a full stop. Now, this matter, the Honorable Supreme Court wants to see that entire selection process is completed by a particular date. So therefore, and my instruction is, this point was not instruction, also there in the Arunima SLP. This point was taken, which was, my lord, ultimately not found to be accepted by the Honorable Supreme Court. And that is the reason they have come lately questioning, my lord, the virus of this prior teaching experience. So I would conclude by submitting that, firstly, this is intra-virus. Secondly, the word void should not be looked into from an extreme interpretations, because in the light of paragraph 47, past service for the honest is a recognition. And thirdly, this point was taken before our bench, division bench, and ultimately have shown the SLP also, and not found favorable. So therefore, my lordships may not pass a favorable order for the writ petition. These are my respectful submission.
So far I am concerned, my lord, can number 2, I am accepting the submissions of Mr. Mittal. Only thing you also have given the copy of the SLP. Can you see the point of law number 12 and ground number 12? It has assailed the very awarding of prior teaching experience 10 marks. And the Supreme Court said no ground for it. No good grounds for it. So therefore they cannot add it. And more particularly paragraph 7 will also take note of this and sequence of sentences of this. The paragraph 7 they say online application were made, we participated, then we approached the authority for taking care of it. So they had everything within their mouth.
In the month of October.
And in respect of the recruitment notification, paragraph 7 of the these are my answers.
Commission,
I mean, for the commission, I
would like to see the list, tainted and untainted, how you have given the preamble of that list. What is the note?
keep it at 3 p.m. Will come with the list.
It is not necessarily you have to come today itself, because I do not want to hear the reply of the petitioner today. I will go through all these things. I will require the list. And the petitioner will reply on the next day. The queries that is passing through my mind, I'll put forth so that everybody can come.
In order to assist the court,
Yes.
first things. The first judgment was delivered by the Honorable Supreme Court from the appeals carried from the division bench's order.
That is here.
The thicker judgment, paragraphs 49, 50 be looked into. After that, the West Bengal Board of Secondary Education, citing, dearth of teachers.
Paragraphs 49 and 50. Yes.
Now, citing, the situation likely to be faced by the students, had moved an application, and ultimately, as my learned senior friend, Mr. Anindya Mitra, pointed out, the Supreme Court regulated the entire process, saying that this has to be done by this time, that has to be done by that time, everything has to be completed by 31st. Now, today your lordship is looking into a petition which was, admittedly filed on 1st of November, 31st October, 1st of November. It was taken on record. Now, this writ petition, apart from anything else, suffers from gross and unexplained delay. And it is at the instance of persons, who, knowing fully well the terms of recruitment, participates in the process, knowing fully well that these are the particulars that they are likely to be fulfilled and they are not likely to be fulfilled. Had they been so vigilant over their rights, then perhaps in Orunima, when Orunima is one set of untainted candidates. Today, I don't find any averment. I take it. I don't find any averment in the writ petition as to who the writ petitioners are, apart from saying that they are eligible to participate. I take it they are also equally untainted candidates, but who were not recruited previously. Similar was Orunima. The fact remains, in Orunima, whatever the stand was taken, same prayer was sought to be foregone. A bunch of writ petitions was taken up. A point may be taken, that Orunima did not say that I am not pressing the prayer, but some other writ petitioner did. The prayer for declaration of the rules to be ultra vires was not pressed. It is deemed. Thereafter, the matter travelled to the Honorable Division Bench. Mr. Bandopadhyay, appearing for the state has invited my lord to paragraph 28. My learned senior friend, Mr. Mitro, invited your lordship's attention to paragraphs 3, 4, the submissions. My lord, apart from that, once again, my lord, please have a look. I need not read it, my lord. Paragraph 35, what the Honorable Division Bench felt that in judicial review, whether that, my lord, can be 34, of course, and 35 thereafter. My lord, what can be done? What is permissible limits of judicial review? Now, my lord, today looking at the entirety of the matter, this order of the Honorable Division Bench, at the instance of Arunima Pal, travelled to the Honorable Supreme Court. My learned senior friend invited your lordships to the grounds. This Honorable Supreme Court was definitely aware about the grounds, and ultimately, my lord, the Honorable Supreme Court, by rejecting the SLP at the threshold, there is no merger. But what happens is, my lord, the division bench's verdict remains. Now, my lord, a collateral challenge after July, August, September, no challenge, nothing. The examination is permitted to take place. The examination is held. My lord, they are stopped, if I may say so, my lord, with greatest of respect, from challenging after participating in the entire process, knowing fully well about, my lord, what are the possible consequences. Just to, my lord, negate today, the publication is in the offing. In today's morning matter, your lordship wanted us to take instructions. Kindly visualize, my lord, the attempted recourse to a proceeding under Article 226 also has to, my lord, satisfy the fundamental test of delayed recourse to a proceeding under Article 226. Someone who is indolent or an acquiescent litigant, who acquiesces with the entire thing, who accepts Arunima, and he doesn't carry or she doesn't carry anything beyond the dismissal of the SLP by way of a review. Whether it is entertainable, maintainable is another thing. But the fact remains, now another round of challenge, just to prevent the selection process which has been, my lord, earmarked by the Honorable Supreme Court to reach its logical conclusion. A writ petition is today filed just to prevent the commission from doing whatever is supposed to be done.
Very well. The list,
Yes.
please bring.
My lord, I will. My lord, just see, if your lordship.
I don't want the names. The manner in which it has been published is required. Names, the court is not concerned.
Lord, we have it. Just give me 2 minutes. Okay.
All right, you make a printout and give. That is all right.
Your lordship,
I
keeping it tomorrow.
Not tomorrow, next week.
Another matter is fixed, my lord.
10?
Well, we will.
Another 2 or 3 matters.
All right, then Monday I can keep it. The earlier ones which were filed, please give the numbers also so that they can come.
Your lordship will keep it on 12th. Mr. Bandopadhyay is leading me. Now, if he can assist your lordship's court in the event, he's. Other matters have been kept on 12th.
Some has
Some are
been,
10th.
some it has been mentioned kept on 10th, but then I don't mind keeping it on 12th also.
Let it be hard out.
Yes, 12th.
All the matters, my lord.
None is without on the issue. With the best of respect.
Then, my lord, my point of demur also need not be kept open. Since your lordship keeping on 12, let them also serve the learned advocate general in the meantime. Because I made the submission with my demur.
All right, all right. You will give me the
Kindly
manner-
indicate in my lord's order.
I'll mention it.
Yes.
The manner in which it has been published. Right.
Manner in
Names,
Very,
preamble.
very, very
That
good,
is
very
important. The names are not concerned. I'm not concerned with the names. I have followed your submission, but then the court, for the purpose of taking into consideration the Arunima Paul's judgment, all these things.
Kindly visualize. Arunima Paul threw a challenge to various issues, including marks. This writ petition is only restricted to marks. I could have understood that this writ petitioner Bhim approached the court along with Arunima and could have segregated his writ petition so as to invite a decision from the court specifically on this issue. Today, by filing a writ petition in the month of November, and suggesting
So that is the reason I wanted the earlier writ petitions also to come on board.
earlier writ petition is already.
No, they say some are pending.
No. We are on this issue, no.
I do not.
No, on this issue.
Age of those other petitions are also put the same. They may be 1 or 2 days older to each other.
There are some.
They are nothing from me.
All right, let us see.
I am averse to the cacophony.
No, yes, let us see.
List is there, documents
Yes.
speak, and without, let us argue on the question of law, not being swayed by tainted content.
Yes.
The question of law has been suggested.
1 minute.
Formal order for the addition.
I will. Mr. Bhattacharya, I would like a reply on the issue of Arunima Pal, the estoppel issue. Something else.
Doesn't arise, they're different petitions.
Yes, I get that.
But there is
And something else is also playing in my mind. The principle of obiter dicta will also be required. You please bring certain judgments on this.
Question of constitutionality of the has not.
Very well. Please be prepared with this and the judgments and everything. Please.
My lady, just one point, if I may make.
Yes, madam.
Yes, if I may make one point.
And who are you appearing for?
Logistically. My lords, my lady, I appear for successful candidates, untainted, and we are before my lady. We have taken the exam successfully. We are only here to say 2 things.
Is
One,
there any
that the
application on your behalf?
Yes, it's CAN 4, my lady. It's been filed as an
Alright, it's not
implement
there in the
application,
list.
CAN 4. CAN 4. But may I just make 2 points, my lady?
Has
One,
not been
my
solved.
lady, in Sanjay Doloy, where 2 judges of my lady's court, the Calcutta High Court, actually heard this question and said that the policy, this is a policy decision, prior work experience being considered and being awarded 10 marks. Because you get more senior teachers, you get more experienced teachers, and that the judiciary should not travail into what is clearly legislative policy. One. Second point, my lords, is Sanjay Doloy's judgment was confirmed by the Supreme Court in July of this year. So that has attained finality. The third point is this, my lords, that this prior experience criterion, 10 marks, prior experience being given, is actually quite the norm. The UGC regulations on minimum qualifications for appointment of teachers 2018 also has prior experience as a criterion for recruitment, very similar to what is before my lady. So this prior experience category cuts across the board when it comes to teaching and has been upheld in multiple high courts, including my lady's high court. So these are just the 2-3 points. And of course, my lady, I'll appreciate the opportunity of assisting on the next date.
All right.
I'm so grateful, my lady. I'm very grateful.
CAN 4 has not been served. Kindly request.
Yes, my instructing counsel will serve CAN 4. Please serve CAN 4.
It's not there in the list
Oh,
also.
it is not there in the list. Oh, actually, very good.
It's only CAN 1 which is here, 2 and 3 is also not here, and 4 is not listed.
My lady, I believe it's been filed today.
Please serve CAN 4 all the parties.
Yes. Please serve CAN 4.
We don't get the cost title when we go to different forums.
2 or 3 হয়েছে তো 2 or 3 আসেনি 4 চলে এলো আচ্ছা
I'm grateful that my lady heard me. I'm grateful. Please serve CAN 4. Yes.
জীবনের প্রথম রিটে আমি তোমাকে হারিয়েছিলাম প্রথম রিটে হেরেই আছি আমি জিতি এটার পরে আমি কনফিডেন্স হয়ে গেছিলাম
the certain provision of the recruitment, but then you are supposed to stay, isn't it, in that other matter?
I'll come from the morning.
Recruitment notification dated 29th May 2025, published by the School Education Department, is impugned in the instant writ petition. Stuff. More particularly, the weightage of marks provided for prior teaching experience is challenged. According to the petitioners, the same is contrary to Article 14 of the Constitution of India. Stop. The notification seeks to create a class amongst a class, which is impermissible. Stop. Paragraph. Three connected applications have been filed seeking intervention. Stop. The applicants and the respondents in the writ petition oppose the submission and the prayers of the petitioners. Stop. The matter has been heard to some extent. Stop. The petitioners shall reply on the adjourned date. Stop. Next paragraph. Let a copy of all pleadings be served to all the parties. Stop. As there is a challenge to the vires of the rules, comma, let copy of all documents be served to the learned advocate general. Stop. The matter is made returnable on 12th November. Stop. Learned advocate representing the commission is directed to produce the preamble of the list published by the commission relating to the tainted and non-tainted candidates. Stop. Couldn't published by the commission in compliance of the direction passed by the Honorable Supreme Court.
Submitted to
Anything more to be included in the order for anybody?
No.
No, this will suffice. Service direction is there and the list to be.
Point be kept on.
That is.
Lordship, add one line that this addition of
Then later
paragraph
on they will
can
say
1,
we
2,
did not
3,
add.
whatever are there.
It will be taken up for consideration. The numbers will be there in the order sheet. So all are being heard together.
Yes, that's my only reason is that this matter most likely it will travel. Most likely.
Certainly, not most likely. Oh,
Either way.
It has been brought to the notice of the court that several writ petitions on similar issue is pending consideration. Stop. Let all the writ petitions be placed on board on 12th. Learned advocates are requested to supply the writ petition numbers to the officer attached to this court for enlistment.
Now the question of maintainability be kept.
The issue of maintainability, as raised by the respondents, is left open. Anything else? No.
Without document on which petitioner I want to rely.
I have mentioned in the audit that all documents pleadings to be circulated. Please, everybody will circulate everything so that nobody is taken aback. Because this has got a long way to go.
This time we do not want anything happens where we don't participate.
Right.
We suffered a lot.
Yes.
That could be.
এটা এখান থেকে খুলে যাচ্ছে এটা এখানে be handed over to the officers. In case there may be others also. In case it is there, please hand over.
Item number 4.
We have taken instructions. I'm sorry.
Yes.
We have taken instructions. First of all, Milord, the commission ordinarily, not in a position to, consider this. Only if it is my lord's order, they will be keeping and making, a departure, and they have, we have tried to, implore on them so that it is done by tomorrow latest. Because tomorrow the results are published, and your lordship will also set a cut-off date. This sort of matters cannot be considered. 21st July was the last date for filling up of forms. We don't have any material placed before the court which warrants your lordship's extraordinary consideration. A cut-off date may be made. That this has to be the last date within which, if any application is made, the commission will be considering it.
But why will I fix a cutoff date? There is only one candidate.
So here it is one candidate, by tomorrow he has to go. Assume, your lordship is with them. And since my lord has been kind enough to, inquire from me, and I have also, informed your lordship that we shall be taking instructions. But ordinarily, the commission is not in a position, because it really does not have that infrastructure, to give a hearing and consider it and everything, at this stage. Because, tomorrow, if the results are published, written results are published, the commission is more, working on that.
Here the petitioner is from UP.
He says he is working in a UP school.
Service teacher in
Uttar Pradesh.
And the writ petition was perhaps filed, after sheet show.
Yes.
After 9.
During the vacation bench, I have filed. Petition 50 pending vacation bench.
No, vacation bench, but after the order was passed
Yes,
in
yes, yes, absolutely.
this Tisha Ghosh, right? Tell me one thing.
After the written results, it will not be possible for us. Kindly visual.
Just tell me one thing.
Yes.
What exactly the commission wants to see? Whether they are in-service teachers or not?
In the column, they have printed back because they have, according to your lordship, they could not have.
Right.
Let us assume, whatever is falling from your lordship, we accept it. The fact remains, there is no representation prima facie, apart from post order, not pre-order. That I am working in this school, kindly consider me. I could not fill up the relevant column. What is not there? Today, the position becomes is, after having party, and one limb of argument can be, in the absence of a demand for justice, whether your lordship will be entertaining this sort of a matter.
I see
71 Supreme Court stands in the way.
I see you've given me a list with 8 candidates.
That is, post order, we have called them for hearing.
Right.
Today.
You all want to see whether they are in-service candidates elsewhere or nothing more than this.
They say that they are in service. I don't know.
Yeah, this is you want to verify.
Yes, verification.
Nothing.
In a substantive post.
Right. Can they not forward the documents in your mail and you all can see it? Why is the requirement of their appearance?
Petition itself.
I could have understood that this exercise was done by them on the day when they filled up the forms.
The petition we have annexed. Kindly come.
You have annexed your documents.
Page 62, kindly say another petitioners. Page 62.
Consider this only. They are not required to appear or
Page
nothing
62,
of
kindly
this
see.
sort.
Page 62, kindly see. This is another petitioner. Kindly see. This is Directorate of Secondary Education, Uttar Pradesh.
Another petitioner means party.
Yeah, yes.
Person is a party.
Yes.
Arup Kumar sheet.
Uttar Pradesh কাজ করতে এখানে কাজ করতে
Salary slip is being attached.
Yes. Then the page 65.
All 4 candidates, everything is attached.
Salary is higher. 90,000.
সেটা তো ওর decision.
Whatever.
You will be losing experienced teachers.
Document পাঠিয়ে দিতে বলো,
You are appearing for the commission. You are not appearing for the petitioner. You have to differentiate. He
Your
is
Lord,
confused. But who is he appearing? Whether for the petitioner, proposing or opposing?
Then kindly come to page 65.
বলে দিচ্ছি।
65, then kindly come to page 65.
No demand for justice. Kindly read.
Yes, I have followed that.
Oh, no.
Tell me one thing. You participated in the examination knowing fully well that you will not get that extra marks. All on a sudden,
In the column, there is
there was no provision.
There is no provision whether you are a sponsored teacher of the state of West Bengal.
I have understood, but then why have you come at such delayed point of time? The
After getting the order of, by the or coordinate bench of this honorable court in Chichago.
that this is what the commission is saying, that you all are fence sitters and you all
We are not
want
the
to
fence
take
sitter, my
the
lord.
advantage.
Kindly see the online application. In the online application, they what?
Please come.
And then please see page 76, everything was there.
1 minute. This 10 marks is to be allotted at this stage, not in the written examination.
No, no,
Written
not-
examination is separate. The result
After written.
after written, so it hardly matters. Achha, the petitioners claim to be in-service teachers of government-aided schools outside the state of West Bengal. They participated in the recruitment examination pursuant to the recruitment notice dated
30th May 2025.
30th May 2025, published by the School Education Department of the state.
Page 67.
The advertisement prescribes 10 marks to candidates having prior teaching experience. Stop. The application details required to be filled up by the candidate puts in a question as to whether the candidate is working as teacher in aided/sponsored school under West Bengal government. Stop. As the petitioners are not employed in this state, accordingly, they could not mention the details of their prior teaching experience. The petitioners have annexed their documents. Petitioners have annexed documents. There hobe na. Documents in support of the submission that they have prior teaching experience. Stop. The commission is directed. No, paragraph. Admittedly, in WPA 22321 of 2025, a coordinate bench of this court passed order on 23rd September 2025 to consider the past experience of the candidate if she is otherwise found eligible. Stop. The learned counsel representing the commission opposes the prayer of the petitioners. It has been submitted that no demand of justice was filed by the petitioners prior to approaching the court. Stop. The petitioners are fence sitters, and only after order was passed by the court in the matter of Shirsha Ghosh, ওপরে যে 22321 বললাম না, ওখানে পার্টির নামটা লিখে দেবেন তো, ওপরে বলেছি, এই যে এখানটা, আর এই জায়গাটাতে লিখে দিন সুপ্রা। The instant writ petition has been filed. Stop. The petitioners filled up the application form be aware of the terms and conditions of the advertisement. Step. No explanation has been forwarded for approaching this court after such a long period of time, and especially after the written examination is over and the results are expected shortly. Stop paragraph. The court notes that admittedly the petitioners never made any approach before the authority highlighting their grievances. But however, but as the petitioners have annexed documents in support of their past teaching experience in a different state, and in line with the decision passed by the court on 23rd September 25 in the matter of Shirsha Ghosh within brackets Supra. Accordingly, the court directs the commission to take into consideration pages, give me the pages, particular pages to show that they were teachers elsewhere.
39, page 39.
Acha, 39, pages 39.
44.
39, 44.
65.
And
62, 65.
62, 65. 4 candidates, 4 pages.
Yes.
Check up the page numbers and in case there is any change, please let the officer know.
I will in.
All right.
Yes.
Accordingly, the court directed to take into consideration pages 39, 44, 62, and 65.
Annexed to the writ petition. Stop. If the commission approves the past service, not approves, accepts such past service of the candidates, then necessary steps pursuant to the recruitment notification dated 30th May 2025 shall be taken. Disposed.
Within a period of
what period? Why is period required?
Well, this will again be now circulated, and next will again 200 matters are going to come up. 2,500 like these candidates are there. And they have chosen to remain in deep slumber. Only promptitude is after.
Publication of panel 24th November.
All right. So this marks will be taken up for consideration at the time of preparation of the final panel.
No,
not prior to that.
Kindly see the classification of marks.
Yes, please show. Please show.
Yes, yes, yes. Kindly see page 116 once.
Yes.
Kindly see my lord, schedule 2A.
Hmm.
First of all, written examination. Then education qualification 10 marks. Then B, prior teaching experience, thereafter oral interview 10 marks.
It is not necessarily that the sequence is followed. Thing is whether you will get the marks at the time of final preparation of the panel or not. So it is the the commission shall take a decision in the matter at the earliest.
Only one humble request.
Yes, sir.
It is understood. Kindly pardon.
This will not create a precedent.
No. This post publication of written results, this will not be possible. At some point of time, it has to stop.
No, how does written examination
Milord, it has an
have
impact.
any nexus with the marks?
Immediately after written examination, Milord, the verification stage begins.
That is his
Yes,
answer.
you'll
Now,
verify,
my lord,
you'll verify at that
that's
prior
why,
to
my
that,
lord, I'm
thereafter.
So therefore, if candidates today, from tomorrow again, they have a right definitely to invoke the jurisdiction of article, of your lordship's court. The question is, whether your lordship is going to entertain this sort of a matter. I'm just, making this submission appearing for the commission.
Even I am trying to understand that this marks will be required only at the time of preparation of the final results.
6 lakhs candidates has participated in the process, out of which, there may be some candidates who have experience. Not all. There are freshers also. So, whoever has participated with the experience, they have disclosed, and we have that, in our system. Now, today, if someone comes to your lordship's court and citing orders made by your lordship's court, in the month of October, or and tries to persuade your lordship that this be considered, nothing prevented them from approaching your lordship's court all this time. Apart from that, prior to sitting in the examination, they also did not come to your lordship's court. So kindly bear this in mind,
notification after written examination, thereafter, my lord.
No, but then you should have come earlier. You
No, my lord.
knew.
On 14th, my lord, we have filed the writ petition. We sub the copy.
May, in the month
Doctor.
of May, the publication of the notification was there.
Written examination.
How does written examination got to do with your marks? 10 marks.
Lordship, very small matter. Petitioner is here, Lordship.
Which one?
Next matter, Lordship. Interest on gratuity
Take it.
for delayed payment, Lordship. Kindly taken up, Lordship.
28?
Yes.
29 also, my lord.
Similar matter, Lord.
देखिए एक मिनट 28 টা देखिए receipt showing payment of deficit court fees আগেরটাতে receipt showing payment of deficit court fees and the affidavit of service.
Yes. And I handed over the page.
Changes are there.
Yes.
ওই পেজগুলো একটু মেনশন করে দেবেন
Affidavit service দিয়ে দাও।
Put it down in a piece of paper and hand over.
We have written.
You've written?
Yes.
Yes. Affidavit service.
Yes.
Delayed payment of gratuity, Lordship.
Is it who's for the petitioner?
He is for.
What do you want?
Based on gratuity, ma'am.
Revised? Which revision?
So part of
Arindam Babu. 2019 revised gratuity. আমি পেছনে লিখে দিচ্ছি ঠিক আছে
Much of the less.
29 same.
I am for the state, my lord, in this matter.
Let me see ফাইলটা একটু দেখি সার্ভিস রেখে দেবেন
হ্যাঁ হ্যাঁ দিল যে
আরে উনিই তো স্টেটের
29 affidavit of service.
revised gratuity.
Yes. Ropa 2009.
Yes.
29 এটা.
And you want revised gratuity? This post. Next one. 30, who's there? Nobody is there. Call your other side.
31. Ma'am.
Lordship, in the application column in 267 is my item in second half. I've waited for, can it be placed sometime before Lordship rises today, or can it be uplifted somewhere in the application? I'm waiting for long. I have a handicapped person who is being represented by the sister Lordship. Item 267 of the application column. Lordship, Zahirur Rahman for the corporation, Lordship.
Where is he?
If Lordship wishes, then I can give him a call.
Bring him prior to rising.
Number one.
Jalpaiguri matter.
I appear for the alleged contaminant.
Is the petitioner there? Item number 1, Jalpaiguri. Yes, I can see.
Last few occasions, these to appear here. Somebody used to appear here. I don't know.
Mr. Jha, please unmute yourself. What happened to the
Yes, your lordship.
state?
Yes.
Please
Am I
come.
audible, your lordship?
Yes. Can you give me the order sheet?
Next page.
The order dated 1st September 2025, passed by the Honorable Supreme Court in special leave petition within brackets civil diary numbers and so has been placed in court. Stop. The operation of the order.
That is the appeal court order.
The?
Let's see the date over there.
Yes.
From your
10th March.
Yes, that is the appeal court order.
Achha. কি বললাম, the order operation of the order of the Honorable Appeal Court has been stayed by the Honorable Supreme Court. Stop. Next. In view of the above, the application for contempt shall be delisted. Stop. Liberty to mention after disposal of the appeal by the Honorable Supreme Court. Next.
The order is kept on record.
Order is kept on record.
Item number 2.
In this matter, Ms. Motion.
My lord, I am appearing for the petitioner, my lord. My lord, today, my lord, I have received the affidavit of the alleged contempt number 1, my lord. And my lord, I have also received the compliance report of contempt number 2. So, my lord, I am praying for 2 weeks time to file reply, my lord.
I am for the
been complied.
There is no, sir. I am
No,
for
my
the I am for the respondent number 3, contempt number 1. So I was the responding authority lordship to in purported compliance lordship. I have given a affidavit of reply to the contempt notice lordship, where lordship I have categorically stated that though in terms of the order dated 30th of April 2025, this honorable court was directed the Jila Parishad to act on in terms of the order, but that we are not the competent authority to deal with the entire issue, because let's kindly see the order dated 30th of August 30th of April 2025, the para 11.
My lord, your lordship kindly consider, my lord, just before 5 minutes, my lord, I have received the compliance report, my lord.
Let me finish. Let me finish. She will get the chance. Lordship, let me finish. The para 11 of the order, lordship, it has been categorically directed to the Jila Parishad to take steps for widening.
Jila Parishad is acquired or what?
No.
What
No,
is
lordship.
No.
No. My lord, kindly appreciate this. My lord, I am appearing on behalf of the alleged contempt number 2. There is a direction from your lordship. Yes, the concerned, my lord, the executive officer of the concerned Jila Parishad being the district magistrate Alipurduar. Now, my lord, I am representing the alleged contempt number 2. There is a direction from your lordship to file affidavit in compliance. Your lordship has been pleased to the Jila Parishad to take steps in accordance with law, if any land is required. Now, my lord, it has been found that the competent authority who is, my lord, taking up this work of widening road, that is WBSRDA, West Bengal State Rural Development Agency. So, my lord, in compliance of your lordship's order, my lord, this is my affidavit in compliance. My lord, the communication has been met before the authority concerned to take steps in accordance with law, and they have made communication to the concerned authority not to take up any construction work in the disputed land, that is the Annexure, my lord,
All right.
document annex.
The affidavit of compliance
Yes.
filed by the
Lordship, I have filed the affidavit of compliance, Lordship, that because it is since a circuit bench matter, it is lying with the circuit, Lordship.
written with the records. Stuff.
Yes, Lordship.
The contender number 1 has also filed an affidavit of compliance before the circuit bench. Stop. Let the same be tagged with the records. Stop. Learned advocate for the petitioner seeks time to file a reply to the same. Stop. Released on 11th of December. The reply may be prepared and circulated prior to the adjourned date.
Grateful, Lordship.
I'm grateful to Lordship, my lord.
Affidavit দিয়েছে তো affidavit of compliance exception ও করতে পারে
Last question. Learned advocate appearing for the Malad Pradhan. Contempt number 1. Malad prayed for adjournment for filing Malad the compliance report.
Yes.
Malad.
Lordship.
May I submit? Malad, though their lordship direction was that they remove the construction of the side land of the state highway. At the time of hearing of the writ petition, the learned Gram Panchayat submitted that the lands belong to them. And after hearing this, your lordship was now, my lord, if your lordship can keep 1 minute time, my lord, keep some photographs. Yes, my lord.
Where is the affidavit of compliance?
No.
Wait.
But this is the previous
Lordship.
picture. Now,
yes, please wait.
Lordship, I am appearing for the contempt number 2, Gram Panchayat.
Yes.
Lordship, the affidavit is not ready. Lordship, kindly give 1 week's time. In the meantime, I will file the affidavit, Lordship. I am praying unconditional apologies, Lordship. I had intimated my client to come before the court to file the affidavit. Lordship, he has not turned up.
Clear photograph. This was the land. Now the fourth
Lordship, may I, Lordship?
Yes.
Lordship, I am on behalf of the contender number 1, Lordship. I have compliance report filed in the department, Lordship, already.
All right.
No copy have been served.
Lordship.
Learned advocate representing the contender number 1 submits that affidavit of compliance has been filed before the circuit bench. Let copy of the same be served upon the learned advocate for the petitioner, and let a copy be tagged with the file. Stop.
Now the kindly have a look present.
The contender number 2 seeks time to file affidavit of compliance.
Lordship, may I, Lordship? Last question, I have appear on behalf of the LS contender number 1, but in the order sheet it recorded LS contender number 2, Lordship.
It should be 1. Time to file করার জন্য released on 11th of December. The affidavit of compliance by both the contemners shall be served upon the learned advocate for the petitioner prior to the adjourned date.
This is the present position.
Keep it with you. Next day I'll see.
But only one in that, my lord. Kindly give direction in the meantime, my lord. No construction is to be carried on, my lord.
Yes, 4.
Lordship, my name may be recorded. Anirban Banerjee for content number 2, Lordship.
All right. First time appearance.
Grateful, Lordship.
Is this how the cause title in a contempt petition is to be mentioned? This is not the way. You have set out your entire contempt application in the cause title. Your prayer is also the same thing. Then your contempt application is to be dismissed. Where are the violations?
Come to the prayer A, Lordship. Page 14.
Yes, that's violating the court's order, but what is the violation?
Order is directed to consider my representation in the
Right, and for that you are required to write the entire petition in your prayer and your cause title. Where is the order?
Order, Lordship, page 53.
And this was carried in appeal.
Yes, Lordship, the appeal was disposed of. That appeal order I have annexed, Lordship. Another petition, Lordship, not this.
Not this.
Similar type of this.
Oh, similar prayer. Serve. 8th January returnable.
Appeal page 55. Up to 16, similar, Lordship.
Same order date also same.
Yes, Lordship.
All right, same order. But then next time be careful and check up as to how the cause title and the prayers are to be set out in the contempt.
Number 6.
কিসের 6?
16.
আর নেই তো জলপাইগুড়ি।
In this matter, I am for the petitioner. Last occasion, your lordship was issue rule against the lordship.
Against the contemner is the Pradhan of the Gram Panchayat. All right. Has the order been complied? Not yet. Who are you representing? Did you file your Wakalatnama? In the afternoon. All right. Yes.
There has been no action subsequent to the order as of now. Kindly allows me some time so that the order may be.
Why has no action been taken despite court's order and despite communication? 5th December 23. And we are approaching December 25. 2 years have elapsed in the meantime.
Yes, well, because the order was not being understood by him, but 1 month may be given or 3 weeks may be given so that the proceedings may be initiated by him as per the directions of the.
The court granted 12 weeks time. It must be for a particular purpose. If the order could have been complied within 2 weeks or 3 weeks, then the court would have granted only 3 weeks time. There was no reason for the court to give extra time, right? What does this person do? Fisheries. So he is more interested in his business rather than doing his official work. The court is not accepting your apology. Nevertheless, please come. Mr. Haider Ali Ghazi, the Pradhan of the Gram Panchayat, is personally present in court in response to the contempt rule issued. Stop. The order of the court dated 5th December 2023 has not been complied with till date. Step. No plausible explanation has been placed before this court for not complying the order passed. Stop. Next. Hearing of the contempt application stands adjourned till 15th January 2025. An affidavit of compliance shall be prepared and circulated prior to the adjourned date. Stop. The contemptor is directed to remain personally present on the 15th.
One small request, Your Lordship, if the contempt application may be served. We have received the copy, but the copy is somehow misplaced. That may be.
So see how efficient he is. He receives a copy and misplaces it.
Your Lordship,
Doesn't understand.
evidence of the, okay, we will assure that acts in accordance with.
Let him pay the charges for the same.
No.
Upon payment of charges, let copy be served. Yes.
My lord, I am for the petition. On the earlier occasion, your lordship was pleased to direct rule.
Last day I could not appear, but prior to that it was complied, and since there is.
Has it been complied?
No, my lord.
I have got a copy. Your Lord,
Or nothing has been
No,
communicated.
but then
How can
you should
They have-
communicate.
They have also received, Lord. The difficulty is, Lord, I just explain.
No, don't explain. You are for?
Every time.
Who are?
Panchayat Pradhan.
Panchayat Pradhan.
Every time, Lord, we serve a notice, he refused. We had to, Lord, paste it in his wall. Then he does not come. Repeatedly, Lord, we are serving him notice. Lord, for spot verification, we have given notice. For hearing, we have given notice. Lord, every time he is refusing. This is the difficulty, Lord. And Lord, your Lordship directed to cause an inquiry and then giving an opportunity to them of hearing. Lord, then hearing was given. Now, Lord, ultimately it is found that in the plot there are 4 decimal of land. He has constructed a land in 1 decimal of land and renovated the house with.
Where is the order? Where is the
Lord,
order?
the land has been classified as JOL without converting, my lord. This has been done. 2023 order passed, my lord. Within that period of time, when the hearing was given, he has already completed the construction. No steps taken.
I must say, Lord, there are 2 phases. One is that his father already
Where is your affidavit of compliance?
Lord, I could not prepare it. Lord, I have got every document.
No, what do you mean to say you could not prepare? You say it was complied long back. Even then you couldn't prepare.
Lady is, Lord, was she's a lady, Lord.
So what?
She was also underwent an operation. That is a difficult thing, Lord.
For last 2 years, my lord.
The order is October 2023. 2 years have elapsed.
This has been complied in the month of July 2020.
What is to be done? She should be punished.
But the difficulties, Lord, they really could not understand the consequence, Lord, that inspection.
The moment some order of punishment is passed, they will, from the next time, they'll become conscious and they'll learn.
I have made them understood, Lord, your Lordship knows, Lord, the lady has come at 9:15 in High Court.
So what?
Even
How
Lord,
does it matter?
Even, Lord, there are prior incidents, Lord, which when she was, Lord, ill, Lord, I was also, Lord, in loop because on the last day I could not appear. The matter was called.
That is your problem. It was only an order of consideration, and that couldn't be done. You took more than 1.5 years after contempt is filed to comply it.
Only, Lord, that part, that, Lord, inspection part, Lord, that really they did not do. Then, Lord, a notice was given to them. They did not receive the notice, neither they appeared, Lord, in the spot.
Where is the order? Let me see.
অর্ডারটা কোথায় গেল? পাচ্ছি নাকি? ছিল তো এখনই ছিল, আমি দেখলাম। I'm sorry, Lord, it is here.
Their representative were subsequently present, but this is the attendance sheet on 10/7, 9/7, and inspection, everything, Lord. Your Lordship would kindly please. My Lord.
Who prepared this reasoned order?
Lord, I have taken instruction, Lord. She has given, after hearing, Lord, there was an initial opinion.
Who prepared it?
Office of the Lord Panchayat.
The executive officer or who?
Lord, what I could get it from her, Lord, she said, Lord, the secretary.
Secretary.
Others, Lord, all Lord has written it in English.
Yes.
Lord, this is the document they have relied on the other party, Lord. This is the application, and Lord, the other documents, Lord, they have relied. In Bengali also there is another order, Lord, which they have.
There are 3 private respondents. Sheikh Shanu, Akhtari, and Salahuddin.
My lord.
But Salahuddin is the son, Sanu is the father who is dead.
Shanu is the father who is dead.
Who has constructed the first floor,
All right.
ground floor, and thereafter not sanction was taken in 2021, 2022. Lord.
Where are the dates mentioned? First page of the order, you mention that it was found that the ground floor was constructed according to the plan. Where are the details of the plan?
In the first floor, there is no plan. But the second floor, this is the document. That is the reason that I was trying to give a lot.
Look at the order. The last line, plan was sanctioned. Where is the date?
11th November 2020.
Where is the date mentioned? Is it there?
Yeah, just.
Is it there?
In that, Lord, they have said, Lord, because it is there in the plan also, Lord.
You don't have a copy of the order with you?
The original, Lord, I have given to you, Lord.
You must be having photocopies.
Lord, I'm having, Lord, lots of documents, Lord, of the notices. There are 2-3 notices, Lord.
Sir, the reasoned order is important. There is no mention about when it was sanctioned. The petitioner alleges that the land was classified as JOL and a construction has been made.
That is also, Lord, I have classification of land, Lord, in the BLRO report, Lord. They are talking about there are 2 lands. In one is, Lord, Rayati, and then...
You may have a lot of documents and facts with you till it transpires.
Compliance, Lord, affidavit, Lord, indicating... Also.
Please come whenever you choose and I impose costs. Please come.
This 26 2021. This is the plan. If your Lordship would kindly peruse for a second.
The contemner is personally present in court in response to the rule issued. Stop. The affidavit of compliance has not been prepared. Stop. A reasoned order dated 10th July 2025 has been placed before the court. Stop. There is a mention of a plan being sanctioned by the Gram Panchayat. Stop. There is no detail. The details of the plan are not disclosed for the reasons best known. Stop. There is no permission for either renovation or construction of the first floor.
Ground floor.
despite noticing that the construction was made without taking any permission, the Pradhan opined that the construction is not an unauthorized one. Stuff. The on the prayer of the learned advocate representing the contemner, opportunity is granted to file an affidavit of compliance. Stuff. The order of the court was passed on 3rd October 2023, and direction was passed to consider the objection alleging unauthorized construction within a period of 3 months from the date of communication of the order. Stuff. The order of the court was promptly communicated to the Pradhan. Stuff. There is no explanation as to why there has been delay in complying the order passed by the court. Stuff. Accordingly, the affidavit of compliance directed to be filed shall be accepted, subject to payment of cost of rupees 5,000. In the Office of the Bar Association, High Court, Calcutta. Stop. The matter is made returnable on 11th of December 2025. Stop. Copy of the affidavit of compliance shall be served in advance to the learned advocate representing the petitioner. Stop. The contemner shall remain personally present in court on the adjourned date. Please do. And give a photocopy.
Grateful to your lordship.
একটু পড়ে একটু পড়ে দেখে নেবেন অর্ডারটাতে কপি দেবে You hand over a copy of the reasoned order.
I have a copy, but I could
Yes.
that is a photocopy.
জানি আমি
Yeah,
লিখেছি
just-
একটু চেক করে নেবেন
আমি কমপ্লায়েন্সের কপিটাই দিয়ে দেবো আপনাকে
I'm appearing on behalf of.
Yes.
I appear for the alleged contemner, my lord. Contemner is present before your lordship.
Why nobody appeared on the last occasion?
Lord, it seems, my lord, that the person receiving, my lord, at the receiving section, my lord, possibly, my lord, there was a communication gap not placed before him. I told him, my lord, but for non-compliance, that is not an explanation, but I know. He has fixed a date for, my lord.
Again, the Pradhan.
Pradhan, my lord. But
December 23 is the order passed.
but I cannot explain.
Simple order of consideration, not complied.
But I cannot give an explanation for this, my lord. Lack of understanding or lack of communication, my lord, should have been complied with. The date has been fixed. If your lordship kindly allows me to come back on the after that hearing, my lord, that with the reasoned order, then your lordship decides, my lord. Because
Please come.
14th of November, my lord, date
The
has been fixed for hearing.
Contemner Topon Manna, Pradhan of the Gram Panchayat is personally present in court. Stop. The order of the court dated 5th December 2023 has not been complied with till date. Stop. Learned advocate representing the contemner seeks time to comply the same. Stop. Release the contempt on 15th January. Stop. Affidavit of compliance shall be prepared and circulated prior to the adjourned date. Stop. The contemner shall remain personally present in court on the adjourned date.
Extremely grateful, my lord. I'll come back after contempt.
I'm appealing for the petition of lordship. Alleged contender was directed to submit the affidavit in compliance, lordship.
Submitted?
No.
No?
Well,
Yes.
what has happened is that we have already complied our part of the order.
You are for?
I am for the alleged contemners. We are the
All.
The part.
Then our part, what does it, our part?
The difficulty, the part which is yet to be complied by the Union Public Service Commission has not been made a party by them. We have sent the file to the Union Public Service Commission after concluding the disciplinary proceeding.
Please show the court's order.
My lord. No, court order. Kindly see the last order passed by your lordship.
Yes.
12 June, lordship, 2025.
Submitted that there has been delay in compliance with petitioner. Currently placed before the ministry. Who are the contemners? You are for the Public Service Commission?
No, no, no.
You are for the
I am for this Ministry of Defense.
Ministry?
Ministry of Defense.
Ministry of
He was a
Defense.
grade 1 officer of the Ministry of Defense. A disciplinary proceeding was initiated before his retirement.
I see 12 June's order records that the file is placed before the ministry.
We have already sent it to the Union Public.
The advice of the Public Service
Yes.
Commission is required to be
Yes,
obtained. What
yes.
steps did you take to obtain it?
We have sent a letter long back. This is what we have received it on day before yesterday from the Union Public Service Commission.
What does it say? Give a copy to him.
Copy আছে? কেটে দিয়েছিল না? No, respondent.
What has happened? The disciplinary proceeding is pending or what?
Disciplinary proceeding is concluded. Now, since he is a grade 1 officer, to give effect to the disciplinary proceeding, we have to seek advice of the Union Public Service Commission. That is where the matter is stuck. We have completed our part.
Every third lawsuit that
And the petitioner has retired from service.
Yes.
He is not getting his terminal dues.
Admissible dues are being paid, has already been paid. Admissible dues. Now, the part which are subject to the disciplinary proceedings could not be paid because of this Union Public Service Commission. They will send our advice on the basis of the entire records. Thereafter, only we can give effect to the final order of the outcome of the disciplinary proceeding.
Did the Director General Border Roads Organization take a decision in the matter?
Disciplinary proceeding has come to an end, decision taken, but advice is to be sought.
Followed. When did it come to an end?
Because he did not cooperate. That was a ground. If your lordship kindly come to the earlier order, there was a ground because the disciplinary proceeding was concluded on 19th. The hearing was concluded on 19th February 2022, and we asked him to file his written brief of arguments. He filed it after 2 years, more than 2 years. On 20th April 2024, it was given.
Why did you wait for 2 years? Was there any requirement for you to wait? Had he suppose not given it at all?
Well, we issued umpteen notices upon him.
Very well. A person doesn't come up and you'll keep waiting. The court is going to take you to task. Please come.
And this order was assailed before the Honorable Appeal Division Bench. Now, the Division Bench has modified the order. So,
March 2020.
whether this contempt is maintainable before your lordship is your question, my lord. Because Division Bench has modified the order.
You have not raised that issue ever. Have you?
This is the second time the matter is appearing.
lordship, division bench, lordship order, lordship.
It has been modified. Now Now this order gets merged with the division bench order. That is annexed. That is annexed.
Annexed to what?
Annexed to the contempt petition.
Contempt petition filed by the petitioner.
এই তো আমার তো কপি সার্ভিস করা আছে।
Contempt petition lordship.
October 2020, this is the.
Page 9, page 9.
There are only. Page 9 is the communicating letter.
In our copy, it is page 9. The appeal court's order. Kindly see copy ta diyo. Kindly see, my lord.
In the contempt petition, there is no
আমাকে
order of the lordship order is annexed here, lordship.
আমাকে কপি দিয়েছেন পেজ 9.
And communication is given, lordship, which is annexed E, lordship, page 9. Order passed by lordship on 13 March 2020.
1 minute.
It is a complete violation of the order. Lordship was pleased to pass an order. Direction was given to disburse the terminal dues. That has not yet been paid. Only provisional.
That is modified by the honorable division bench.
Page 8 হচ্ছে court's order.
Division bench.
That is suppressed.
Affirm the lordship order.
9 হচ্ছে এটা.
Only the time period for the disciplinary proceeding that was given.
Kindly see the division bench order, internal page 6. The appellant undertakes to cooperate in the inquiry and he filed his written notes after more than 2 years.
Where is the back sheet of your contempt that has been served?
কোথায় back sheet কোথায়?
Huh?
Back sheet is not.
These are all your documents.
Subsequent documents are my documents.
This contempt was filed in October.
Yes, yes.
Right? And the division bench's order is in December. How can it be annexed to the contempt?
My lord, this contempt maintainability question is raised, my lord.
Show me the court's order.
That is there, my lord. Kindly see page 9 of my brief. The brief I handed over.
এটা সার্ভিস হয়নি, এগুলো হচ্ছে ওনাদের মক্কেলরা পাঠিয়েছে।
কি বলো ওটা সার্ভিস হয়নি?
It could have been served if in October the contempt is filed. How can a December's order be annexed there?
My lord, I apologize. এইটা সার্ভিস হয়েছে তো, এইটা তো এই তো অশোক অমল ব্যানার্জি।
এটা কোনটা দিয়েছি দেখুন না, কোনটা দেখে দিয়েছি দেখুন না, এই পিটিশন তো সার্ভ করেছি,
এই তো
তাহলে দেন I did not annex that thing. Order of the honorable division bench.
The court records that the order of the single bench deserves no interference.
Thereafter, it has been modified. Kindly see.
Yes, only the time period has been extended.
No, there
More.
are several observations also. The disciplinary proceeding, last paragraph, the disciplinary DP as directed by this order shall commence from the stage till it has reached up to this date. The appellant writ petition shall be entitled to cross-examine the PW.
Yes, that
MW.
is also in December. Time has expired long ago.
The above directions are passed, extending the time to complete the inquiry. The appellant undertakes to cooperate in the inquiry.
March 2020 has not been complied with till date. Stop. The petitioner is a retired employee and a part of his terminal dues are yet to be disbursed. Stop. A disciplinary proceeding was pending against him, and the court specified the time period within which the same had to be concluded. Stop. The time period lapsed long ago. Stop. It has been brought to the notice of the court that the disciplinary proceeding stood concluded in the year 2024. Stop. Till today, the employer of the petitioner is waiting concurrence from the Union Public Service Commission. Stuff. Communication from the Lieutenant Colonel, the officer commanding, dated 3rd November 2025, mentions about a request for adjournment and extension of time be given up to 31st May 2026. Stuff. The aforesaid communicating letter dated 3rd November 2025 mentions about disciplinary proceedings where advice of the UPSC is given in priority cases. The authority is directed to treat the instant case as a priority case and obtain necessary instruction from, not instruction, it will be advice from, necessary advice from UPSC at the earliest. Stop. The contempt, no, further extension of time till 31st May 2026 as sought for cannot be allowed, keeping in mind the that the petitioner has long retired from service. And as a petitioner is a senior citizen and long retired from service. The contempt application is made returnable on 15th January 2026. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
I'm extremely good. I'm extremely good.
Next.
After 15th, because
after 15th
because
January.
Because I will have to go to before 15th, Lordship.
No, before 15th.
Because I'll have to go to
wherever you go. Wherever you go.
For the purpose of the Kali Puja, Lordship. 18th is Kali Puja. Due to that reason, I'll have to go there, Lordship. Before that, Lordship.
5th of February. 5th February 26. Yes.
26.
number 5.
Yes.
Lordship, on the last occasion, Lordship had directed to intimate the respondents because they did not appear.
For the state respondent.
But I am appearing for the respondent number 6.
Lordship,
What is the review?
Indeed, Your Lordship. Lordship, kindly sees my prayer of the main writ application, Lordship. My prayer was for quashing of the FIR which was registered against me, Your Lordship. Entally Police Station 170. Now, Your Lordship, the order which I am praying for review, order dated 9th of July 2024. Your Lordship may kindly seize. Lordship, the last page, I believe page number 19, the petitioner prays for compounding of the offense. My first fold of my submission is this. The petitioner prays for compounding of the offenses, Lordship. Lordship, I'm the accused of the case, Your Lordship. Compounding of offense cannot be at my pretext, Your Lordship. The de facto complainant has not made a statement or has not approached before the case for compounding of the offense, Your Lordship. I had either instead, Your Lordship, I had prayed for quashing of the case. Firstly, Your Lordship, I was arrested. All the offences which are registered against me are below 7 years, Your Lordship, which means that the Anish Kumar principle would be followed, that I cannot be directly arrested. Now, Your Lordship, from the court premises only on 1st June, I was directly arrested. I was kept into custody from 2nd of June to 16th of June, Your Lordship, without any notice, without anything, Your Lordship. So my first grievance is regarding the overaction done by the police, where my fundamental rights have been infringed, Your Lordship, for which I had approached this honorable court for writ. Second,
what is the position of the trial now?
Charge sheet has been submitted, Your Lordship.
That is recorded in the order. More than a year back.
Lordship, charge has not been framed yet.
Yes, it takes such a long time for framing of charges. Charge sheet was submitted long back.
In the year 2023, Your Lordship. Then? Charge has not been framed.
And you want the quashing to be done now?
Lordship, we had prayed for quashing before filing of the.
No, but then at this late stage.
Lordship, because
so discharge application before the learned trial court, my lord.
Lordship,
discharge is something else.
That is part of.
Lordship, if my fundamental rights are being infringed, I have remedy under Article 226 of the Constitution, Your Lordship.
And that will be quashing of the entire proceeding?
Lordship, if there is illegality in the way FIR has been registered, in light of the Bhajanlal principle and Salib.
Upon hearing the submission made on behalf of the petitioner, it appears that the criminal proceeding is at the trial stage. The charge sheet has been submitted long back, but it has been submitted that charge has not been framed till date. The incident in question took place inside the court premises on 1st June 2023 between the learned advocate and his client. Next. The petitioner being you are the advocate of the client.
Client. Now I am the advocate of the client, but the FIR was registered.
Shobik Ghosh.
Client. Is the client.
I'm representing Shobik.
She's representing the client. I am for the advocate.
Achha. The litigant before the learned trial court, Shobik Ghosh, prays for quashing of the criminal proceeding. Paragraph. More than 2 years have passed from the date of the incident. The charge sheet also appears to have been filed long back. At this stage, the court is not inclined to pass any order for quashing of the criminal proceeding. the parties are relegated to the, not parties, the petitioner is relegated to the learned trial court for making necessary prayer. Stop. The application for review stands disposed of.
Lordship, Lordship, if your Lordship may also
Enter dispose করবেন. Consequently, the connected application stands disposed.
Lordship may also take into consideration that the word compounding is mentioned, reflected in the order, your Lordship.
Achha. The recording of the sentence that the petitioner prays for compounding of the offences stands deleted from the order dated. আগেকার অর্ডারের ডেটটা একটু বসিয়ে দেবেন.
9 to
Yes, next.
Lordship, with your Lordship's permission, Lordship, my 41A notice was also not given, your Lordship.
You raise all these issues before the trial.
Lordship, but my fundamental rights
Yes,
have been violated.
40.
How do I?
But I am for the municipality, my lord.
For the
The chairman is present.
pursuant to your Lordship's direction, my lord, last occasion, my lord, leave was granted, my lord, to add the my lord, DPPG as a party in the proceedings, my lord, and to serve copy of the,
Anybody appearing?
that I don't know, but I have served, my lord, upon the DPPG, my lord.
Who appeared for the state in the
Dada, এটা একটু দিয়ে দিন না। In the read, my lord.
the state was not a party.
Yes, ma'am.
The DPPG was a party, but the state was not. Is Mr. Bhaskar Boisho over here? Anybody from his chamber?
Generally, my lord, he appears on behalf of the DPPG.
Anybody
Well, after
from
your lordship's order, my lord, the chairman themselves has requested that the order of this court of may be complied with. Because of this fact, my lord, till now, my lord, repeatedly the chairman, because he made me the last 31st 10
you
2025.
please get hold of somebody, either Mr. Boisho or somebody from his
Or my
chamber.
lord, Lordship, kindly let this matter be taken up next Thursday so that I can serve a notice.
Somebody is personally appearing.
No, no, not this matter.
He
Yes,
said-
Not
chairman is
No, no, not this matter, my lord, 167.
No, these matter also.
there is a direction for personal appearance.
Yes, my lord.
Let him wait. Let Mr. Boisho come. Call him. Pass over. Next.
একবারে ধরবে।
Lordship, in this matter, Mr. Shundipan Banerjee is appearing for the Howrah Municipal Corporation. Lordship, this is the report, Lordship.
But my instructions are that, my lord, the demolition has not been, my lord,
Lordship, partly
totally
demolition
done.
has been conducted, Lordship.
Partial.
Partial demolition. Yes.
Next date of demolition. When will the complete demolition take place? Tell me one thing. Can you
12th
understand
January.
anything from this photograph? Can you understand? At least I cannot. What can you understand from here? Why place these type of documents before the court, which
Can kindly give another.
it cannot be deciphered? When will the complete construction take place?
Lordship, some more days are required, Lordship.
Please come, learned advocate for the parties admit partial demolition of the unauthorized construction. Stop. Learned advocate representing the corporation seeks further time to conclude the demolition work. Stop. In view of such submission, release the contempt on 5th February 2026. Demolition of all unauthorized construction shall be made prior to the adjourned date, and an affidavit of compliance be filed on the next day.
Lordship, I'm for the petitioners.
42 Lordship, I am for the alleged contender. I am led by Mr. Shamal Kumar Das. Lordship, yesterday the order has been complied. Lordship,
Instruction,
these are the photographs.
The illegal Gumti that was supposed to be removed, the municipality removed the illegal Gumti yesterday. But my only grievance is that from today itself, the private respondents are again coming and trying to create another Gumti over there. My only grievance is this much, Marshal.
Please come. Learned advocate representing the petitioner admits demolition of the unauthorized construction. Stop. It has been submitted that though the construction, unauthorized construction has been demolished, comma, but the private respondents are in the process of reconstructing it again. Stop. Titagarh municipality.
Lordship.
Learned advocate representing the Titagarh municipality produces photographs in support of the submission that the unauthorized construction has been demolished. Stop. The municipality is directed to ensure that reconstruction at the said place does not take place in any manner whatsoever. Contempt disposed.
I'm great. Dear Ichira.
What is your name, madam?
Miss Krishna Yadav.
Your name will be recorded.
Lordship.
All right.
I'm for the petition.
I'm for the contempt, Your Lordship.
And your lordship was pleased to direct the BDO to ensure that no construction of road is made on my land. My lord. Even after communication of this order, my lord, they have constructed road enclosing some portion of my land.
Encroaching your portion.
My land. My land.
The Jila Parishad or who?
Gram Panchayat.
Panchayat, Your Lordship.
Panchayat.
Lordship passed this order on 10th January 2024.
Yes.
Thereafter, on 18th January 2024, the BDO sent a letter to the Pradhan with the certified copy of my lord's order, and they ensured that there is no further construction will be made, Your Lordship. BDO Pradhan also sent to the in reply to the BDO that he complied the order of Your Lordships. Lordship, I have the documents before to show Your Lordship.
No, but the petitioner says that despite this, the unauthorized construction has been made. This is the allegation.
Lordship, the Pradhan says, Your Lordship, in compliance of Honorable Court's order date 10/1/2024, any further works at the said location was closed from the end of the Frisganj Gram Panchayat. So the date of completion of this work was 14/12/2023, which is very earlier of the court's order dated 10/1/2024. Hence, there is no question of violation of the Honorable Court's order, Your Lordship. Lordship passed the order on 10th January.
Please come.
Lordship, may I submit my report, Your Lordship?
Learned advocate representing the petitioner submits that despite the order of the court dated 10th January 2024 being communicated to the contemners, the Pradhan of the Gram Panchayat constructed the concrete road over the private land of the petitioner. Stop paragraph. Learned advocate representing the block development officer, being the contemnor number 1, submits upon instruction that the BDO has been intimated that the subject road was constructed prior to the order of the court being passed. Stop. After the order was passed by the court, no construction has been made. Stop. It appears from paragraph. It appears from the order dated 10th January 2024 that a titled suit in respect of the subject plot of land is pending consideration before the learned civil court. Stop. As it has been submitted that the construction in question was made prior to the order passed by the court, by this court. Accordingly, the court is not inclined to pass any further order in the matter. Stop. The parties are restrained from making any further construction. Stop. the construction already made shall abide by the order passed by the learned civil court in the pending title suit. The contempt application stands disposed of.
Pradhan is not party in the civil suit, Milad. Pradhan is not party. Civil suit is pending between the private parties.
Yes, yes.
Lordship,
Whatever will happen, will happen.
Milad, the construction.
Give you a report. Construction, you bring it to the notice of the
Yes, Milad, I have.
civil court.
Milad, Pradhan is not party.
Next.
Before Puja my lord, steps could not be taken, my lord, for stipulating that you will campaign as a party and serving copy upon.
Why?
It could not be collected.
September, you couldn't collect.
Before Puja, it could not be collected.
Now you know.
Yes, my lord.
Achha.
Only 2 weeks time may be given.
Learned advocate representing the petitioner seeks extension of time to implead the present incumbent.
And subcop.
Stop. Hearing of the contempt application stands adjourned till 18th December 2025. Stop. The present incumbent shall be added as party in the contempt application, and copy of the contempt application be served upon the
new incumbent.
Respondents, contemners / respondents. Next.
45. After the petitioner, my application. The order has not come yet. Has not complied yet.
Has not been complied.
Already demolition has been taken place, and most of the portion of the structure has already demolished. This is the unauthorized construction, single story structure. My lord, this
Not
is the
fully
present
demolished.
report.
Not fully demolished.
Just some pillars are there.
Please come.
This is the photograph, my lord.
Learned advocate for the petitioner submits that the order of the court has not been complied with till date. Stop. Learned advocate for the contemner relies upon the report forwarded by the engineers of the corporation signed on 29th August 2025, mentioning that major portion of the unauthorized structure has been demolished and the building has become uninhabitable. Inhabitable. Stop. The paragraph hearing of the contempt application stands adjourned till 5th February 2026. Stop. An affidavit of compliance showing full demolition of the unauthorized structure, including the pillars, pillars and the outer walls, shall be placed before this court on the adjourned date.
Actually, may I get a copy of the bill?
Give.
Technical service be kept on record.
Yes, service is taken on record.
I am for the petition. My lord, order, my lord. Page 22, my lord.
Order not complied.
Partly, my lord. Page 22, my lord. 4th paragraph has not been complied.
So, Kamal kar diya.
Unauthorized करना तुम्हारे.
Ki? 46 to.
46.
हाँ.
No,
Ki onno naam?
Asfa Khan. Asfa Khan.
Ashfa Kamil. I'm appearing for the contemners.
Yes, has the order been complied?
No, my lord, not complied. Paragraph 4 has not been complied.
It has not been complied.
Because of the fact, my lord, your lordship takes this. There is an appeal
Yes.
which is
Still
to
pending.
be, yes, and there is an order of stay of the special officer building. That's what have been communicated. And the final order is going to be passed on 14th of November by the tribunal. So your lordship keeps this matter at least a week after the 14th of November.
All right, please come. Learned advocate for the petitioner alleges that the order of the court has not been complied with.
No, he's saying partially complied with.
Learned
Hearing was
advocate
finished.
representing the alleged contemner submits that an order of stay has been passed. Acha, stay of the order of demolition has been passed by the Municipal Building Tribunal in Building Appeal number 31/2024. Stop. It has been submitted that final order is due to be passed by the tribunal on November
14
2025. Stop. Next. In view of such submission, release the contempt once again on 18th December 2025 for recording further updates.
Good. Well, let that record be kept on
Yes,
record.
yes, এটাকে রেকর্ডে রেখে দিন।
Every service we kept on record. also.
আপনার অসুবিধা হচ্ছে না তো ডিকটেশন হতে?
Lord,
Yes.
regarding item 40, my lord, passover matter, my lord. Actually, Mr. Basu, my lord, tried to contact with him, my lord. Mr. Basu, my lord, my lord, due to his cardiac problem, my lord, he, my lord, admitted to Bellevue Hospital.
When? He was here day before yesterday.
That I don't know, my lord. Just now I came to know Mr.
His
Basu.
juniors.
He told me, my lord, today no junior is here.
None of the
requested-
juniors are here.
He told me, my lord, over phone. He told me. My lord, so he requested so
Chandan
that
Ghosh.
matter may be, my lord, fixed any day, my lord. Thursday or Monday, as your lordship desire, my lord. Most probably today, he has admitted. Yesterday at Bellevue Hospital.
Page.
Learned advocate representing DPPG is reported to be indisposed. Step next. In view of the same, hearing of the contempt stands adjourned till 27th November. 27 November. Step. Personal appearance of the who has come? Chairman of which municipality? Bodhvati municipality. Stands dispensed with for the time being. Stop. Learned advocate for DPPG shall come ready with all necessary instruction on the adjourned date. Next.
Item 167, also the same matter, my lord. And my lord was pleased to direct me to serve, my lord, upon the DPPG as well as the DLB, my lord, have served, my lord. Kindly let this service be kept.
No, let it remain. Let it
That
remain.
matter, my lord, have served. Kindly record it, my lord. The notice.
My lord has directed the chairman to have been passed.
That matter also, personal appearance. 167.
167.
167.
Acha, the same order will go down in 167.
167.
What is this affidavit of service?
My lord, no affidavit of service, but in earlier matter, my lord, that I have served, my lord, and I have handed over the notice, my lord, which I have sent to the DPPG, my lord. And with track record, my lord, I have.
Acha. In this matter, 167, there is nothing.
Yes, yes, yes.
Oh, দুটোতেই তাহলে লিখে নেবেন the notice upon the DPPG be written with the records.
In the second matter, 167 DPPG and DLB. And first matter only DPPG.
প্রথমেরটা DPPG, পরেরটাতে DPPG and DLB.
Yes.
And the passer appearance.
Grateful, my lord.
Personal appearance dispensed.
167 is okay.
দুটোতেই।
Grateful.
Item 47.
47, your lordship, appear for the petitioner. This is an order dated 13 June 2023, your lordship, page 31. Lordship, going by your lordship's order, there is absolute non-compliance. May I place the order once? Page 31, your lordship. Lordship.
All right. The property included in the list of immovable properties assessed in the name of the private party and tax collected.
Lordship's observation.
There was a direction of passing reasoned order. Where is it?
Lordship, the reasoned order was to the effect, your lordship, 12 weeks. That the first observation, and with regard to that it is the petitioners are the private parties, whether, Your Lordship, the very ordering portion, whether KMC has any right to decide the title of the
Let me
title.
see the reasoned order, please.
Petition has been filed after I have passed the reasoned order challenging the same. So in my most respectful submission, this
And is it by some other party?
by Contempt Ghosh.
Same party?
Yes. This matter, madam.
Date of the reasoned order?
It's after your lordships, after the contempt appeal, that I admit, my lord, on 19th of June 25. If your lordship wants to see, your lordship sees this.
Yes, one
And
minute.
the petition is there. This has been challenged in this writ petition. So this contempt is won.
This, Lordship, I'm not aware of.
8844. Yes.
My fault.
No, আমি জানি না এটা। এটা আমি জানি না।
This is not made known to you?
No.
Please come.
Lordship, Lordship, may I be permitted to, Your Lordship, see the same? There is an order passed on 9th June 2025. I don't know if my the Learned Counsel for KMC is relying on that order.
It's 19th of June 2025. It is signed by the Additional Municipal Commissioner.
Lordship, this is the order, 19 June. Lordship, I have a copy of the order.
Then you must be aware?
No. With regard to the subsequent filing of the writ petition, I am not aware.
Acha. The petitioner alleges non-compliance of the direction passed in the order dated 13th June 2023. The contempt application was filed on 22nd May 2024. Stop. It appears from the submission made on behalf of the parties that on 19th June 2025, order has been passed in compliance of the direction passed by the court. The in compliance and allegedly in compliance on 13th June 2023, and the reasoned order is impugned by the petitioners in WPA 20296 of 2025, which is pending disposal. Stop. Upon hearing the parties, it appears that the order of the court has been complied with, though at a belated date. Stop. Under such circumstances, the court is not inclined to proceed with the contempt application any further. Stop. The same stands disposed of. Next.
Grateful, my lord.
10 September.
Item 48.
For the petitioner.
Yes. Is it the corporation?
That I appear pursuant to your lordship direction, will not have some copies, will not. This is will not kindly see your lordship's order, will not dated 15th May 2023.
Yes.
Is the order under contempt, will not kindly see, will not the private person responsible, will not they had will not lost in all the forum. Will not the order of the special officer building was challenged before the building challenged. Building tribunal dismissed it. Now, Millard and affirmed the order. Thereafter, Millard, a civil revisional application.
So what happened thereafter?
Yes, after service of the Millard order, Millard, some Millard demolition, Millard has been done. This is not demolition, Millard, only Millard, the asbestos shed has been removed, and Millard, few bricks have been removed. Millard, the order of the SOB says entire first floor is illegal.
All right. Yes.
Before corporation start, I am the person responsible. My lord, the demolition was taken place on 9/10/2025. And thereafter, my lord, certain portions are there.
Sir, you are not a party over here.
Only, my lord, thing, my lord, we request Kolkata Municipal Corporation to grant some time so as to enable us to remove all the other, my lord, remaining portion, remnants.
Let me hear.
What I am trying to say.
Lord,
Are you there?
48, I am not appearing, but there's another matter, 206,
That is
Alright.
also, my lord.
which are connected together. Same premises.
No,
Not,
my lord,
sorry, adjacent premises.
neighboring premises, my lord, they are-
Adjacent premises. So
That
your
is-
lordship takes it up,
Yes, ma'am.
takes.
Let
both
me
the-
hear, madam is here.
Well, some portion have been demolished, others are under occupancy. That is the difficulty. We could not demolish the entire portion that has been alleged to be unauthorized.
And you expect the occupants to
police
move
has-
out
My lord,
voluntarily?
police has been intimated on diverse dates, but cooperation from the police is also necessary, my lord.
The police went there. This is our letter addressed to Kolkata Municipal Corporation. We are praying on behalf of, my lord, the person responsible to grant some time, my lord.
Unauthorized
May I file my report, my lord? Your lordship kindly peruses one report.
And at the same time, my lord, I'll take up 206.
Unauthorized construction has not been demolished, has not been কি বললাম? The unauthorized construction has not been demolished till date. Stop. It appears that only the asbestos shed and a few bricks have been removed. Stop. The first floor, which is unauthorized, still remains. Stop. Learned advocate representing the corporation relies on the instruction forwarded by the engineers of the corporation dated 25th September 2025, mentioning that the premises is fully occupied, for which the demolition could not be executed. Stop. Next. The
Your lordship might kindly go through the last two paragraphs of my report.
yes, the corporation appears to have sought assistance from the Jadavpur police station for providing assistance at the time of assistance for removing the for removing the occupants from the portions constructed unauthorizedly. Stop paragraph. Who will be the higher officer of this Jadavpur PS?
Officer in charge. Kindly consider our letter.
Officer in charge.
No, officer in charge Jadavpur is there.
TC South.
Will it be South or will it be some other?
That I have to check, but usually it is DC South.
Subject to correction, my lord, we have applied before the Kolkata Municipal Corporation to grant some time. We'll demolish remaining portion. Kindly see the letter, my lord. Otherwise, since I am not party.
When?
My lord, 16/10, I have written this letter. 16 November. 1 month we are praying for. Lordship, kindly allow that space.
Today is 6th November. So 10 days time,
Yes,
according to you.
10 days. See the letter and my lord.
All right.
We'll do that.
Achha. The
responsible.
officer in charge of the Jadavpur police station is directed to seek further assistance, not further, additional police help from his superior authority to ensure that the unauthorized construction is demolished at the earliest. Stop. The contempt application is made returnable on 18th of December 2025.
Only one indication may kindly be given. 16th undertaking is there. But if it is not taken place, kindly appreciate. Before
Deputy
that,
Commissioner.
kindly appreciate before that.
Service is taken on record.
Deputy Commissioner, South Suburban.
Kindly
South
appreciate.
Suburban Division.
Higher authority, bracket DC, South Suburban Division.
At the same time, 206 are similar, identical. Neighboring.
Will be taken up? I'll see later on.
এই দুটো কপি আছে আমি একটা নেব।
ওটা থাকবে না, সুপিরিয়র অথরিটি যেখানে বললাম সেখানে
একটা কপি আমার থেকে আমাকে সুবিধা।
Time for the petition, my lord. My lord, pursuant to your lordship direction on my lord, March 6, my lord, we have served my lord, the alleged contempt, my lord, the affidavit of service. My lord, this is my lord against my lord non-compliance of the order dated December 19, 2023. My lord, at page 19 of my application.
That order was passed, my lord, and communicated.
And not communicated to me, my lord.
No communication. That is
give a copy. The order dated 30th January 2024.
No, my lord.
No.
19th of December 2023 at page 19, my lord.
This is 30th January 2024.
Yes, yes.
Oh,
24. Previously, HGO has communicated for holding an inquiry, and we have also concluded and communicated. They have lost before this complaint before the HGO.
বললাম the communication dated 30th January 2024 by the chairman Agra municipality. Signed on 1st February 2024. Addressed to the subdivisional officer Agra subdivision. Handed over in court today. Is perused. Stop. It appears therefrom that the municipality already conducted an investigation, and it transpired that death certificate of Dhiren Pramanik was handed over to his legal heirs. Stop. Geeta Pramanik, the writ petitioner herein, claimed to be the second wife of the deceased. Stop. The municipality is of the opinion that the first wife of the deceased is still alive. Stop. There is no order of divorce or remarriage. Stop. The municipality has opined that there is no requirement of any further investigation and inquiry in this regard. Stop. Paragraph. Copy of the communication of the chairman mentioned herein above has been handed over to the learned advocate representing the writ petitioner. Stop. The court is not inclined to proceed with the contempt application any further. Stop. The same stands disposed of. Stop. It will be open for the petitioner to agitate her grievances before the competent forum in accordance with law if so advised. Service is taken on record.
Good.
My lord. Lord, I am for the petitioner in this matter.
For appearance record হবে না।
My lord, in this matter, Mr. Bhaskar Prasad Bosu is appearing for
What
the.
has happened to him?
My lord, today morning, my lord, at 5:30 a.m., he was seriously felt illness and my lord fell down.
Yes, been
And
admitted
thereafter
to the hospital.
he was taken to Bellevue Hospital. But just now he is released after
he's
doing all
released,
the
he's
discharge and he is going to. But it was very serious.
All right. Adjourn it.
Yes, my lord.
That is what
Let it be.
petitioner in the-
Or
for the petitioner.
next
today.
If it is
Only
not
today.
not only now, then my lord, Tuesday,
Two matters.
Tuesday,
Next Thursday it will appear.
next Thursday, it will be better.
Only not today.
Lordship.
I am appearing on behalf of the.
Next Thursday.
No appearance.
Next to next.
Why?
I will not be here next.
Keep somebody else.
But I am for the petitioner in this matter.
You are for the petitioner? আচ্ছা ঠিক আছে. On the joint prayer made on behalf of the learned advocates representing the respective parties, released the matter on 20th.
Yes.
20 তারিখ।
আমি নাম দিলাম না।
Item 51.
I am for the petitioner.
Who is the contemptor?
Chairman Ranaghat Municipal. Chairman Ranaghat University and also a lot of executive officers. Ranaghat University. One and two of the content.
None appears on behalf of the contemptors. Let contempt rule be issued. Against both the contemptors. Returnable on 15th January 2025. Requisites be put in at once. 2026 হবে। 15th of January 26 rule is made returnable. Please put in your requisites.
52.
My lord, I am for the petitioner, my lord.
Yes.
My lord, according to your lordship, this I serve the copy of the petition, my lord, upon the contemptor. It's a Pradhan, my lord.
Upon whom?
Upon the contemptor Pradhan. Pradhan of my lord, Jalpai 1 number Gram Panchayat. That is at page 4 of my application. Now, before this service, my lord, there was another service, my lord, but I lost the original copy. This is the second service, this is the first service, my lord. I lost the original.
Rule. আগেরটার সেম অর্ডার হবে। একজন কন্টেম্পটর আছে।
Get folder.
দাদা।
For the petitioner, my lord, from this reference. During the pendency of this application, my lord, the sole petitioner has died, my lord. I've already filed a CAN application, but since there was no direction for service, my lord, I'm seeking my lord's direction to serve up this CAN application upon the opposite party so that matter can be taken up, my lord.
Who is the contemptor?
Prashanto Banerjee. Respondent number 9, my lord.
Pradhan of the Gram Panchayat.
My lord, Champatala Gram Panchayat.
Please come. The sole writ petitioner has expired on 13th May 2025. An application has been filed for substituting her. Stop. For the purpose of proceeding with the contempt application, the heirs of the deceased writ petitioner are required to be brought on record. The application for substitution stands allowed. Stop. The department is directed to substitute the writ petitioner by her heirs and legal representatives, details of whom are mentioned in paragraph 2 of the connecting application. Stop. The learned advocate representing the applicants is directed to serve copy of the contempt application, amended contempt application, upon the contemner. Stop. The contempt application is made returnable on 8th January 2026. An affidavit of compliance shall be prepared and filed on the adjourned date.
Grateful, my lord.
Can disposed.
Grateful.
My lord, I am for the petitioner, my lord. My lord, I am for the petitioner. My lord, on the last occasion, my lord, we prayed before your lordship to get the certified copy from the department, my lord, because the advocate on record, he lost the brief due to shifting of chambers. Subsequently, we went before the department and the department informed us that the case file is before your lordship's court. My lord, I am praying for a leave to get the certified copy, my lord.
Please come. Learned advocate for the petitioner seeks direction for obtaining certified copy of all documents in connection with the contempt application. Stop. Let the file be sent to the department. Stop. Liberty to mention the matter after certified copies are obtained. Next.
In this matter also, Mr. Boshu is appearing, my lord, for the DPP.
Not today?
My lord.
Not today.
Not today, my lord. Thursday.
My lord, 56. I'm appearing for the alleged contemners, my lord. But, my lord, in this matter, we have filed a review of your lordship's order. My lord, that review is review number 307 of 2023. It's not appearing in the list, my lord. But may it appear with the contempt.
Why review? Go in appeal and get it set aside.
So, my lord, I'll tell your lordship. I'll tell your lordships why, my lord. My lord, if your lordship takes the order under contempt, why we cannot go up in appeal? My lord, if your lordship takes the internal page 3.
Yes.
My lord, that will be at page 41 of the contempt, my lord. My lord, your lordship has recorded a consent of the state, which perhaps might have been given also, my lord. I'm not disputing that. that it has been made clear by the learned advocate representing the state respondents that willingness
Kindly make it not to
আরে আমি মামলা করছি না ভাই এটা একটু দাঁড়াও
but আমার যে brief
Yes,
টা নেই, ওই জন্য আমি চাই না।
willingness has been sought from the Gram Panchayat assistants who may be willing to join as the block level assistants. There is no force and or pressure upon the Gram Panchayat assistant to join the block. Then Malad kindly skips over one paragraph. It is only for the candidates who are willing to join the block will be paid from the RGAS fund. There is no threat of non-payment of remuneration to the Gram Panchayat assistants who are unwilling to join the blocks. Now, Malad, the difficulty is that the scheme under which the petitioners were appointed, that scheme is over. For a very transitional period, we were directed to provide 10% funds from the operation and maintenance funds to keep it afloat. Then another scheme came and they were directed to be transported to that scheme so that their livelihood continues. Therefore, my lord, there is no question of any willingness, because if they want to willingly, they want to stay in the earlier scheme. The earlier scheme has extinguished by virtue of efflux of time. That is why, my lord, we cannot go up in appeal, because we need a correction of that order, because there is an error apparent on the face of it.
But I can distinctly remember that this submission was made, and that is the reason it has been recorded. Otherwise, there was no reason.
I am
for
not disputing it at
record.
all.
Now,
But my lord, if the submission has gone down wrongly, my lord, we have no avenue of correction in appeal. We'll have to come before your lordship in review. That is why the review has been filed. My lord, all this I am submitting. My lord,
let the review appear.
yes, my lord, RVW 307 of 2023. But I'll address my points then. I'm only saying that let it appear.
307, 2023. 2023, you said?
2023, my lord.
2023. Why did you not mention it earlier?
We tried, my lord, but it was all throughout was appearing in your lordship's list, my lord. We were watching it every Thursday, my lord.
কি বললাম? An application for review being number such and such has been filed. Stop. Let the same be tagged with the file. Next Thursday.
My lord, grateful, my lord. বুঝিনি।
Has copy been served?
No, I'll check it.
এটা পাইনি বলেই সেটাই বলার চেষ্টা।
Yes. My instruction is that it has been served, but I'll give my learned friend another copy so that she comes prepared for next day.
I am for the Panchayat Pradhan. We have complied with your lordship's order, and we have sent.
38.
Yes, we've written to the SDO quite a few times. No, he's not taking any action on this. We are facing contempt for this. These are the things.
Show me that you have forwarded.
Yes, I'll show you. There's people there.
Kindly add the SDO, my lord. SDO is not party, my lord. After filing the writ petition, order was passed.
So you are aware of it, that the order has been passed?
This is an unauthorized construction.
Yes. It will not communicated, but I am no. I mean, my client has told me that order was passed. Hearing was concluded.
There was a hearing. Found that this is unauthorized.
Construction upon the ponds.
ঠিক আছে না দেখছি Well, we've communicated also to the BLLRO and everybody. SDO has also been communicated.
SDO is coming.
Yes, yes. কাগজ আছে?
Because this is communicated to the BDO.
BDO and then the SDO 2310-2024. Next page, minute.
Next page is
Subdivisional subdivisional police officer. কোথায় আছে ভাই?
Block Land and Land Reforms Officer.
Subdivision Land and Land Reforms. Yes, minute 2310. Memo number 376.
Last হচ্ছে ওই Bengali
Please come. The petitioner alleges violation of the direction passed by the court on 5th December 2023. Stop. Learned advocate representing the contemner / panchayat submits upon instruction that the order of the Gram Panchayat has been forwarded to the subdivisional officer Ghatal with request to remove all illegal encroachment. With a communicating letter dated 23rd October 2024. The submission is that that no action has been taken from the end of the subdivisional officer. Paragraph. It appears from the submission made on behalf of the parties that the panchayat took steps to comply the order passed by the court, and upon arriving at a finding that there has been unauthorized construction, has forwarded all documents to the subdivisional officer for taking further steps in the matter. Stuff next. In view of the above, the court is not inclined to proceed with the contempt application any further. Stop. The contempt application stands disposed of. Stop. It will be open for the petitioner to challenge the inaction on the part of the subdivisional officer in taking steps in furtherance to the order passed by the Gram Panchayat before the appropriate forum in accordance with law, if so advised. Service is taken on record, contempt disposed.
Deeply.
First time.
Everyone want? Not the date.
Evening, not today.
You have a time?
সুব্রত বাবু একটা অর্ডার লিখবেন, none for the petitioner, adjourn for the day. 9 also, 10 also. 10. Next.
11. 312. What's the application? 312. You have a card email?
Seller talking, I am for the applicant worship.
First time? All right, serve. It is returnable on 15th of January.
You have a 14. You have a 15.
14. 14. None for the petitioner, adjourn for the day. Petitioners 16.
First time application.
First time? Please, sir. It is returnable on the 15th of January.
15th. Much obliged.
Eighteen, I am for the petitioner. This is the first time, my lord, the order has not been complied with. With the illegal mutation, your lordships pass a direction to file a representation. We filed, hearing was done, but no order has been passed and nothing has been done.
All right.
My lord, kindly stay within December prior to vacation. My lord, and if your lordships diary is confirmed.
Diary will not permit. 22nd of January.
Much obliged.
So,
Much obliged.
Mr. Panda, I was looking for you. The petitioner is here sitting behind one matter. I have directed her to serve notice upon you. Go through the order and come back. 20th, I have fixed it.
My only request, my lord, only copy maybe. One copy. I shall take my own cost.
Yes.
Yes, yes, yes.
At your own cost, you
Yes,
can.
yes.
Not now. I will serve it by.
ठीक है, ठीक है.
Yes, next. 320, the petitioner is here. পিছনে বসে কথা বলে যাচ্ছে Miss Sulaiman, 320 is your matter.
appearing for the first time, Lord.
All right. Please serve. 22nd of January, it is returnable.
Grateful, my lord.
This is my application appear first time it has appeared before the last.
All right,
Against
serve.
the yesterday.
Street 24, my first time, my lord. It is appearing today in list.
What happened to the appeal?
But the appeal is still pending before the division bench, my lord.
Still pending?
Still pending, my lord.
No stay. Has it been
Yes, my
heard?
lord, it has not yet been heard, my lord. It's still pending. They have just filed it and kept it, my lord. We are suffering huge loss, my lord.
And
Huge loss.
was it filed within the period of limitation or with section 5?
It was filed beyond the period of. I need to just check on the facts, my lord, about the appeal.
Achha, anyway, service returnable on 22nd of January.
My lord, may I beseech your lordship, my lord, the assigned matters pertaining to Kollan Krishnan on the my lord, be pleased to fix a date, my lord.
See, it is there in the list. Please follow the list.
My lord, then only not tomorrow, my lord. Fix Monday, my lord. Some difficulty.
Please Friday. All right, not tomorrow.
My lord.
I'll keep it in mind.
Team number 263 of 2 days leave,
Great.
lordship.
Item number 5.
Yes.
My petitioner is a senior citizen, 89 years old, admitted in hospital. Last occasion, lordship, area matter, CPF to GPF. Last occasion, lordship, DI already been personally appears, and DI lordship calculated the amount and forwarded to the treasury officer. Man, the treasury officer not been released. Kindly, man,
Item 2.
263.
Who is your other side?
Maloy Krishna Singh.
Mala Singh is for the state.
Yes.
263 টা পরের দিনকে উপরের দিকে দিয়ে দেবেন তো।
Lord, may I have your lordships, Lord, with regard to item number 312, appearing for the first time, Lord, I was engaged in courtroom number 15. I could not come at the time of call.
312?
312, my lord. Your lordship was
আচ্ছা,
pleased
ঠিক
to
আছে।
adjourn the matter, my lord. First
ঠিক
time,
আছে,
your lordship
ফার্স্ট
was
এর অ্যাপিয়ারেন্সের অর্ডার করে দেবেন 22 জানুয়ারি।